Right. I'll find out later. Phew. Hello, Judge Hatcher. Are you there?
Yes, I am. Is that Bev?
Yes. Can you see me by chance?
I cannot, but I can hear you okay.
Okay, I'm going to try to. Yesterday, Judge DePel couldn't see me either, but I'm going to try to do something.
Alrighty.
Mr. Cooper,
Yes.
you look like you're going to be a witness in a video deposition with your nice background.
Well, my office background was a little scary.
Looks like the sky.
Just a really well painted wall.
Commissioner Sylvie's here, Judge.
Good afternoon, Commissioner. Mr. Chairman. Okay, my clock shows 1 o'clock. Let's go on the record. Good afternoon. Today is June 3rd, 2020. The commission has set this time for an evidentiary hearing in the following contested case. In the matter of the petition of Missouri American Water Company for approval to change an infrastructure system replacement surcharge, ISRIS. That's file number WO-2020-0190 and tariff tracking number YW-2020-0148. My name is Charles Hatcher, and I am the regulatory law judge presiding over this hearing. Let's go ahead and have counsel for the parties make their entry of appearance. For Missouri American, Mr. Cooper.
Thank you, Your Honor. Ian Cooper from the law firm of Bryden, Swearingen and England, PC, PO Box 456, Jefferson City, Missouri 65102, appearing on behalf of Missouri American Water Company.
Thank you. And for the Office of the Public Counsel.
Thank you, Your Honor. John Kleiser, appearing on behalf of the Office of Public Counsel. Our office is at 200 Madison Street, Suite 650, Jefferson City, Missouri 65101.
Thank you. And for Office of the staff of the Missouri Public Service Commission, Mr. Johnson.
Thank you, Judge. Mark Johnson, appearing on behalf of the staff of the Missouri Public Service Commission. Our address is 200 Madison Street, P.O. Box 360, Jefferson City, Missouri 65102.
Thank you. We do have a couple of remarks I want to make because we are doing this via WebEx. Everyone has been doing great thus far. I think we're all getting used to it a little bit. Everyone, do please mute yourselves, and we will proceed very slowly during this hearing so that every step to allow anyone who wants to speak to unmute themselves. And just a note, there is a WebEx chat function that is a part of this application or web service. That function is not private. It is not confidential, and it will not be able to protect attorney-client confidentiality if a counsel needs to consult with any of their witnesses. I would highly recommend that nobody use the chat function. Okay, let's get to preliminary matters. First, an issue about confidentiality. The Office of the Public Counsel had filed a motion recently asking that the commission recognize the fact that a publicly available private letter ruling is the same as Appendix M in the company's application. And the commission agreed. Missouri American said they did not object to that finding of fact. And we're left now with what appears to me to be a split between the parties as to viewing references to the private letter ruling as confidential or not. I think I can clear this up with a quick question, and I will use our previous method of calling on counsel in the order I just did for answers. Do you have any objections to references to the private letter ruling in this case being non-confidential? Mr. Cooper.
I think the only distinction I need to make, Your Honor, is that we viewed everything, I guess what we were agreeing to was that everything that was a part of the publicly available private letter ruling would be public. The distinction I'm making is that the public letter ruling that's attached as a schedule to Mr. Wildy's testimony is the same in part, but it also contains the redacted information from that publicly available private letter ruling. So I guess the way we looked at it is that anything that's in the public PLR could be treated publicly, but I don't know that that extended to identifying the schedule in Mr. Wildy's testimony as public because it is slightly different.
Okay, what I was trying to get at is the public counsel has submitted a demonstrative exhibit, and let me get to Office of Public Counsel. Let's see where we end up at the end of this. Office of Public Counsel, Mr. Kleiser.
Let me speak specifically to the demonstrative because that appears to be the impetus behind your question. The demonstrative includes information relating to the private letter ruling request that was made by the company. That is an exhibit that was attached to Mr., I'm hoping I'm pronouncing it correctly, Wildy or Wildier, I'm not sure, testimony. It is confidential, and the OPC is not requesting it not be made confidential at this point in time. So the demonstrative would need to remain confidential regardless as to the ruling on the private letter ruling itself.
Okay, Mr. Johnson for staff.
Staff has no objection to the treatment of confidential or non-confidential information subject to the agreement between OPC and the company.
Okay. I am not quite crystal clear where you want to draw the line, Mr. Cooper, but I'm going to give you quite a bit of latitude to draw that line. What I'm trying to do is make sure that we're not going in camera for too much of the hearing. That's all that I'm trying to avoid.
And Your Honor, I agree with Mr. Kleiser in that what's referenced in the demonstrative exhibit is it's just a separate issue from what we discussed in that motion.
Okay. Okay, we have emailed briefly, again on preliminary matters, about submission of exhibits. I want to repeat those instructions for the record. When council submits their exhibits for inclusion into the record, the marking of that exhibit is going to be obtained by emailing your exhibit to exhibits@psc.mo.gov. And those exhibits can be emailed if you are particularly talented at multifunctioning. You can do that during the hearing, but I would expect that that will probably be done after the hearing. And I'm going to set a deadline of Friday to submit those. Do I hear any objections to that treatment of exhibits, specifically the Friday deadline? Mr. Cooper?
No objection, Your Honor.
Thank you. Mr. Kleiser?
I have no objection to the Friday deadline. Just to be clear, though, if at the point in time where we're presenting an exhibit to the opposing counsel, the witness, and of course you, if we were to simply add exhibits at opc.mo.gov at that point, would that take care of the filing or the marking as well?
No, it's going to be two different processes, if you will. So the distribution to council and to myself is what will be used to satisfy that portion of the rule, and also for me to forward your submission on to the commissioners. For your exhibit to be officially marked as entered into the record and added into EFIS, you'll need to do that second step, which is submit it to the exhibits@psc.mo.gov email address.
All right, I understand that, but that would be after a ruling has been made as to whether it's, once it's been offered and a ruling has been made as to its inclusion, I assume?
Yes.
Should we be sending in exhibits regardless of whether or not regardless, but should all exhibits be sent in to be marked independent of whether or not they are accepted, or only exhibits that are offered and accepted should be sent to be marked?
I see. I had seen two different avenues so that you could do it in advance and submit all of your exhibits, and then the ones that were not accepted onto the record just simply wouldn't be marked. But I think you might want to know if you can get an exhibit specifically marked specifically, so that it is then not, when it is not admitted onto the record, it's still marked. Is that correct, Mr. Kleiser?
I believe so. I'm attempting to operate under the traditional system wherein a exhibit would be marked, discussed, and then offered and accepted.
Yes, and because this is a virtual hearing and because of the difficulties in trying to do both of those things all at once, we've tried to bifurcate the system a little bit. The hope was to make this a little bit simpler. So let me know how that's going at the end of the hearing. But the thought behind this was to allow, if you wanted to submit them in advance, you certainly could. But I think everyone is anticipating these will be filed tonight or tomorrow, exactly as in the traditional system, if not as close in time. So you'll offer it, we'll discuss it. There will be, I'll ask for objections, there will be a ruling. And then if it's submitted, great, in the next day or two, submit it to the email address. And that's how we'll get it on EFIS.
All right, I think I understand. And as I said before, I don't object to the Friday deadline. Thank you.
Thank you. And Mr. Johnson. let me remind you where we're at. Did you have any objection to how we're going to treat the exhibits? And specifically, I set a Friday deadline for all of the council to submit those to the exhibits at PSC email address.
No objection to the process or the date. Thank you, Judge.
Thank you. Next on my list, staff had a motion to supplement the testimony of Mr. Oligschlager, and that was presented as being unopposed. The commission will grant that motion unless there are any objections to be heard.
Judge, I would just clarify that the motion is in regard to Mr. Arabian's testimony.
I'm sorry, you're correct. I had that wrongly marked. Mr. Arabian's here testimony. Are there any objections?
The OPC does not object.
Thank you. And hearing none others, it is so admitted. The motion is so granted. That is all of the preliminary matters that I have, and we will follow the orders of opening, witnesses, and cross-exam that the parties have previously agreed to. Are there any other preliminary matters before we get started? Hearing none, let's move to opening statements. Mr. Cooper.
Thank you, Your Honor. Both of our witnesses, Mr. LeGrand and Mr. Wildy, are on the WebEx and prepared to testify today. We will, as we discussed in email earlier, we will also be presenting the stipulation of facts that was filed by the parties previously. The list of issues filed by the parties in this case identifies two issues. The first, and I think the most significant and the one that really gets to the heart of the case, is should MAWC's incremental pre-tax revenue requirement in this matter include a total of $35,328 associated with MAWC's proposal to address alleged normalization violations related to eligible infrastructure system replacements included in MAWC's current ISRIS, currently effective ISRIS. That $35,328 adjustment to the incremental pre-tax revenue requirement referenced by the issue is proposed in order to cure, at the next available opportunity, a normalization issue identified in a private letter ruling, PLR, that MAWC received from the Internal Revenue Service. MAWC's last three ISRIS cases, that's WO-2018-0373, WO-2019-0184, and WO-2019-0389, concerned an issue related to a potential tax normalization violation associated with accumulated deferred income taxes and the reflection of a net operating loss within the ISRIS. The eight at issue in those cases included both accelerated depreciation and what was referred to as the repairs allowance used by the company. In the PLR or private letter ruling, the IRS determined that the reflection of a full deduction of applicable accelerated depreciation amounts without an offset for a net operating loss in computing the ISRIS surcharge constituted a violation of the IRS code as to normalization. The IRS, however, also ruled that there was no normalization violation associated with the Commission's reflection of the repair allowance amounts without offset. Thus, in this case, MAWC seeks to cure the violation associated with the accelerated depreciation only. That request is supported by the staff of the Commission and opposed by the Office of the Public Counsel. OPC witness Riley primarily criticizes the substance of the request for the private letter ruling, in spite of the fact that that request was a very thorough and accurate description of the facts. First, I would remind the Commission that, as is stated in the testimony, the Commission staff was given the opportunity to review the request, did review the request, provided comments that were included with the request, and indicated its belief that the request was adequate and complete. Second, The request provides specific information as to the commission's findings and conclusions in a prior case, and the resulting private letter ruling recognizes that during the relevant time period, parent, this is a quote, parent on a consolidated basis and taxpayer on a separate company basis estimate that taxable income was earned and thus NOLC, or the net operating loss carryover, was utilized. That fact was obviously known to the IRS and did not change its ruling that a NOL must be reflected in the ISRS in conjunction with the recognition of accumulated depreciation as to the accelerated depreciation. There was no misrepresentation of the facts presented in the PLR request, nor misunderstanding by the IRS. OPC essentially asked the Commission to ignore the private letter ruling and reach its own conclusions as to the tax normalization issue. This seems to be a very big ask, as ultimately tax normalization is a tax question for the IRS. As staff witness Oligschlager states, the ISRS is the agency designated to interpret its code and to determine whether the actions of taxpayers, and for regulated utilities, the actions of its regulators, are in compliance with the IRS code. He further points out that while the IRS certainly has no direct power to set utility rates, the consequences of violating the IRS code in respect to the normalization requirements are of sufficient gravity to command the attention of all parties to Commission proceedings and the Commission itself in regard to tax normalization issues and rate proceedings. This Commission previously recognized that the IRS ruling would have some import. In its report and order, in file number WO-2020-0194, the Commission directed Missouri American to file notice with the Commission within 10 days of the issuance of a conclusion or statement of violation from the Internal Revenue Service concerning a possible violation of its consent order and/or normalization rules. MAWC so timely filed the PLR with the Commission shortly after receipt. Because of the IRS's ruling that the company violated the tax normalization rules in regard to applicable ADIT associated with accelerated depreciation amounts, a failure to cure the normalization violation in some fashion could cause MAWC to lose significant tax benefits currently benefiting customers. Specifically, MAWC could lose its ability to claim accelerated tax depreciation deductions. Accelerated tax depreciation allows the company to expense investments faster for tax purposes than for book purposes. This differential, sometimes described as a zero interest loan from the government, is a reduction to rate base. All else being equal, both the company's revenue requirement and the customer's rates are lower when the company can utilize this tax treatment. Making the adjustment as proposed by the company and staff in this case has several benefits. First, addressing the matter in this manner provides more certainty in terms of truly curing the issue with respect to the IRS. As company witness John Wildy explains, the IRS requires normalization violations to be remedied at the next available opportunity. Making the adjustment here would do so. Second, addressing the issue within the current ISRS ensures that the company collects no more and no less than the identified amount and allows recovery to be received from only those customers to which the ISRS applies. Lastly, as a practical matter, the relatively small amount associated with the cure makes this solution very manageable. Staff witness Matt Barnes computes the difference in rates based on whether the $35,328 is included or not. That difference in rates is extremely small. The difference is so small, in fact, that it does not seem to make any sense to essentially play a game of chicken with the IRS over this impact as encouraged by the OPC, given the significant adverse impact for the company and the customers if there is a tax normalization violation and loss of accelerated depreciation. Now, the second issue that was identified on the list of issues, which I do not necessarily see as being unique, was should MAWC's incremental pre-tax revenue requirement in this matter include recognition of deferred taxes associated with accelerated depreciation tax timing differences. Section 393-1000 paren 1, paren A indicates that appropriate pre-tax revenues associated with an ISRIS include accumulated deferred income taxes and accumulated depreciation associated with eligible infrastructure replacements, which are included in a currently effective ISRIS. Missouri Americans ISRIS recognizes accumulated deferred income taxes along with the above referenced or the previously referenced net operating loss deferred tax asset associated with the eligible infrastructure system replacements included in MAWC's current ISRIS. Therefore, we believe it certainly complies with the statute. I'd like to close with an excerpt from the Commission's transcript in file WO-2019-0190. On pages 26 to 29 of the transcript, then Commissioner Hall asked both staff and OPC counsel their client's position in regard to whether they would recommend inclusion of the calculated net operating loss if the Commission found that failure to do so would be a tax normalization violation. Ms. Shimwell for the public counsel stated as follows, and I'm starting on line 14 of page 27. Ms. Shimwell said, public counsel strongly recommends that the Commission allow the IRS to interpret its own rules, and the company is on a path to ask the IRS to do that, and so the Commission should not get out in front of the IRS would be our recommendation. Commissioner Hall stated, what if we got a private letter ruling consistent with the company's position? Ms. Shimwell stated, then I believe the Commission should accept the IRS's recommendation or its decision. Commissioner Hall stated, and set ISRIS accordingly. Ms. Shimwell stated, well, I don't see any reason the Commission would violate or had suggest the company violate an IRS regulation. Ms. Shimwell described in that case exactly where we are today. The Commission has waited for the IRS to weigh in. The IRS has weighed in and indicated that failure to reflect a net operating loss in regard to the accumulated deferred income taxes associated with accelerated depreciation was a tax normalization violation. The Commission should approve the adjustment proposed by MAWC to cure this violation. And that's all I have, Your Honor.
Thank you, Mr. Cooper. Are there any commissioner questions for Mr. Cooper before we move on to the next opening statement by staff? Give everyone a moment to unmute. All right, Mr. Yes, Commissioner.
No questions from Commissioner Root.
Thank you, Commissioner.
No
Mr. Johnson, would you like
questions
to go
from
ahead with- Was that somebody with a question?
No, Kenny has no questions.
Ah, thank you, Commissioner Kenny.
Sylvie has no questions.
Thank you. All right, Mr. Johnson, please go ahead with your opening.
Thank you, Judge. Good afternoon, and may it please the Commission. My name is Mark Johnson, and I am representing the staff of the Commission before you today. As Mr. Cooper indicated, the parties have presented two issues to the Commission. However, staff believes these issues are part and parcel and can really be boiled down to a single issue. And that is, should Missouri Americans' incremental pre-tax revenue requirement in this ISRIS case be adjusted to account for net operating loss amounts consistent with the IRS rulings in the recent private letter ruling requested by Missouri American and to cure any past normalization violation? Staff believes the answer to this question is yes. As such, staff has included an amount in its recommended ISRIS revenue requirement to account for net operating loss and recommends the Commission include an adjustment totaling $35,328 to cure past normalization violations. The issue of the recognition of net operating losses in ISRIS is not a new one to this Commission. This issue has been addressed in some manner in each of Missouri American's last three ISRIS proceedings. In each of those cases, staff and the Office of Public Counsel opposed the reflection of NOL amounts in ISRIS, while Missouri American claimed failure to do so could result in a violation of the IRS Code's normalization requirements. Now, 2 of those cases were litigated. Case numbers WO-2018-0373 and WO-2019-0184. And ultimately, the Commission agreed with staff and OPC's positions, finding that there was no evidence of NOLs being generated during the ISRIS periods, and as such, ordered the full amount of the applicable accelerated depreciation and repair allowance deductions available to Missouri American be reflected in ISRIS rates. However, as I just indicated, and as stated in staff's recommendations, testimonies, and positions filed in this case, staff now recommends reflection of an NOL amount in ISRIS. And you may ask, what has changed? Well, following the issuance of the Commission's order in WO 2018-0373, Missouri American made a request for a private letter ruling from the IRS, generally inquiring into whether the Commission's treatment of net operating losses in setting Missouri American's ISRIS rates constituted a violation of its normalization restriction. In the course of preparing its request, Missouri American shared drafts with staff, and staff provided input and substantial feedback, including explanations and justifications for its positions taken in the recent Commission proceedings. And these comments were attached to the PLR request sent to the IRS for its consideration. In early December of 2019, the IRS provided its private letter ruling. Since its issuance, staff has reviewed it and through its analysis concludes that the IRS has determined that the Commission's actions in prior ISRIS cases did constitute a violation of the IRS Code's normalization restriction. Specifically, the PLR indicates agreement that Missouri American incurred a tax loss during the ISRIS periods in prior cases due to the addition of ISRIS plant, and that this loss must be reflected in ISRIS rates due to the normalization requirements. In staff's view, this finding effectively demonstrates IRS support for Missouri Americans' positions in prior cases that ADIT associated with ISRIS plant additions must be offset by an assumed NOL in order to comply with the IRS code. However, as Mr. Cooper stated, the IRS also determined that the Commission's treatment of reflecting a full deduction of applicable repair allowance amounts did not violate the normalization restrictions within the code. And it is this finding that has resulted in the necessary adjustments to comply with the PLR's findings being relatively immaterial. Failure to cure these normalization violations could potentially result in Missouri American losing its ability to utilize accelerated depreciation. And ultimately, that result could cause higher rates for its ratepayers. Now, while it was stipulated in Missouri American's most recent ISRIS case, WO 2019-0389, that in the event the IRS found in Missouri American's favor, disputed NOL amounts from prior ISRIS cases should be deferred through an AAO, staff does not object to the company's proposal to collect these amounts in this ISRIS proceeding. Doing so now, as explained by the company, has its benefits. Namely, including the amount in this proceeding allows the past violations to be cured as quickly as possible. The applicable amounts would also be recovered only from those customers to which the ISRIS applies. And as the necessary amounts are relatively small, the impact to ratepayers would be minimal. Therefore, it is staff's position that the Commission account for a net operating loss amount in Missouri American's incremental pre-tax revenue requirement in this matter, consistent with the PLR requested by Missouri American. The commission should also include an adjustment totaling $35,328 to cure any past normalization violations committed by the company. And as such, staff recommends the commission approve its recommended ISRIS surcharge revenues in the incremental pre-tax revenue amount of $9,725,687 and approve the rates recommended by staff in its direct testimony. I have with me today staff witness Mark Oligschlager, who will provide testimony relating to the net operating loss issue and to the impact of the PLR requested by Missouri American. Ali Arabian, who sponsors staff's recommendation, and Matthew Barnes, who will provide testimony on staff's recommended rate design. They will be happy to answer any questions you may have. Thank you.
Thank you, Mr. Johnson. Are there any commissioner questions for Mr. Johnson? All right, hearing none, Mr. Kleiser for the public counsel.
Good afternoon, and may it please the commission. So why are we here today? We've already heard from the staff of the commission and we've heard from the company. And the general idea is that we have a private letter ruling from the IRS that talks about normalization violations. Now, both staff and the company would have you believe that the primary question involved in all these prior ISRIS cases was whether or not a net operating loss created a normalization violation. That's not true. The primary question, as identified by staff witness Mr. Oligschlager himself, was whether or not a net operating loss, or NOL, ever existed. And this commission twice determined that the company had not suffered a net operating loss. Then the company decided to appeal both of those decisions. And the Western District Court of Appeals twice told the company, the commission got it right. You have not suffered a net operating loss. So how does that factor into the current situation? Well, the sad fact of the matter is, while this should have been resolved, the company decided to make false representations to the IRS in the course of requesting its private letter ruling. And that has thrown everything into confusion. Now, to get more specific into this, I would like to draw the commission's attention to the OPC's demonstrative. And before I go any further, Judge, my understanding is that people outside of this WebEx will not be able to see the demonstrative.
Yes, Mr. Kleiser, that's correct. I forwarded that to the commissioners, so they will be able to view it while you're talking. But it's not posted up on any shared screen, and our video feed is also not the video that is being broadcast.
All right. In that case, Judge, I will acknowledge the point at which my discussion of the demonstrative reaches confidential information and the need to go in camera. Until then, I will just discuss the non-confidential portions through the course of the rest of my opening, if that's agreeable to you.
Yes, please go ahead.
All right. So the OPC has set forward the historical background behind these cases. And the first thing that we talk about is what this commission reached in its decision in the 2018-0373 case. Now, the first and most important thing I want this commission to recognize is number 20. MOC did not generate any NOL in the 2018 ISRIS period. That was this commission's finding of fact. And in number 19, this commission also noted that the private letter rulings that the company wanted to rely on were not appropriate because they concerned companies that actually had suffered a net operating loss. If we go down a little bit, we can see that what the commission ultimately decided is that although the ISRIS statute requires recognition of ADIT, which might include reflection of an NOL, We cannot allow Mock to reduce its ADIT balance to reflect an NOL that does not exist. Now, like I said, this decision was appealed by the company to the Court of Appeals, and the Court of Appeals affirmed. It said, look, the commission found that no NOL was generated, so we don't have to worry about whether or not there's a normalization violation because you don't even have an NOL. That was the first case. The second case was much strongly litigated, but this commission still reached the exact same conclusion. The company does not have an NOL. Once again, this commission also noted that the private letter rulings upon which Mock was relying were not effective because they concerned situations where there was an NOL, but there wasn't one in this case. This decision was again appealed to the Court of Appeals, who again affirmed this commission got it right. The company does not have an NOL. And now, Judge, I think we will need to go in camera.
Okay, give me just a second. We'll go in camera. Sorry about that. We got to coordinate with IT.
Your submission. Next, you will see that the IRS literally copy and pasted the facts that the company had submitted. And then finally, you will see at the bottom what is attached to the end of every private letter ruling request that explains that it is based on the representation submitted by the taxpayer and that the IRS does not verify the information included. This is an essential point. As our witness, Mr. Riley, explains at length in both direct and rebuttal testimony, the IRS does not consider the facts in a private letter ruling request. It accepts them and rules on them. This is important because, as Mr. Johnson just explained, staff's entire position here is exclusively based on the fact that this statement by the IRS, this repetition of the facts as submitted by the company, exists. They say because the IRS repeated something the company told them, therefore the IRS agreed. That is the exact opposite of how a private letter ruling request works. And last thing I'll say before I leave camera, we will prove today again that Missouri American Water did not have a net operating loss during the 2018 ISRIS period. With that, I believe I am done in camera, and thank the judge.
Thank you, Mr. Kleiser. Everyone give me a second while we switch back to our live feed, if that makes any sense. Okay, thank you for your patience. I am just waiting for confirmation from our computer department. Okay, we are back on. Mr. Kleiser, was that the conclusion of your opening statement?
No, it was not, Your Honor.
Okay, please continue.
Thank you. So, where are we? The one thing that Mr. Cooper did correctly state regarding the private letter ruling is that the IRS concluded that if there was a net operating loss, there was a normalization violation. The OPC's point is that there is no net operating loss. The commission has already determined that. The IRS private letter ruling did not overturn that because the IRS was never asked if there was a private letter rule, if there was a net operating loss. So it's not an issue. Instead, what is left is already what the commission has determined, no net operating loss. And if there's no net operating loss, there's no normalization violation, and hence nothing that needs to be adjusted. It's very, very simple. Now, the attorney for Missouri American Water suggested that the OPC was requesting a big ask of the commission by asking the commission to go against the IRS. Let's be clear, that's not what the OPC is requesting. The OPC is requesting that you follow the letter of the private letter ruling and say only if a net operating loss exists is there a normalization violation. But to acknowledge that no net operating loss exists, as you already have done, and as the OPC will continue to prove. The big ask in this case is actually what the company is requesting. The company is requesting that this commission overturn both of its prior decisions and overturn both of the Western District appellate decisions that confirmed this commission's prior decisions to determine there is a net operating loss based exclusively on facts as represented to the IRS and not what the IRS actually determines. That is a huge outcome and is one of the two major precedential problems that the commission is facing with this case. The second one, and I want to bring this up to address the issue regarding $35,000. Both staff and the company have insinuated that because this case is only worth $35,000, it's not a big deal. The problem, and the OPC will again represent this through the course of the case, is that the effect of this could fundamentally alter how tax treatment is handled for all utilities that appear before this commission. In other words, the effect of this case could be in the hundreds of millions, if not billions. There is a very serious issue regarding whether or not a company can claim a net operating loss based on the fact that it does not immediately receive revenue from plants that it puts into service. The Western District has already expressly rejected that argument, and the IRS never touched it. All we are asking is that the commission continue to follow the law and say that no net operating loss exists, and not accept the company's invitation to overturn decades of precedent. Finally, I would point out that even if you disregard everything previously, there are still problems with this case. That is because neither company nor staff have taken into consideration important aspects of this net operating loss adjustment calculation. In particular, the two other forms of revenue that the company is receiving that offset and eliminate the claimed net operating loss. The first is contributions in aid of construction. This is explained in Mr. Riley's rebuttal testimony, but essentially, contributions in aid of construction are now considered taxable income thanks to the 2017 Tax Cuts and Jobs Act. As taxable income, the SEAC related to these ISRIS cases would have to be included in revenues as an offset to NOL, but neither company nor staff have included SEAC, hence an immediate and obvious problem. The second and more substantial problem is the fact that the pipes that are being put into place through this ISRIS are generating revenue for the company. Those pipes are being used to transport water, which is being sold for profit, hence producing a revenue stream that can offset any claimed NOL that the company wishes to argue. I've already said that several times, the OPC will present the testimony of Mr. John Riley. He is an expert on tax. He has been cited to by this commission multiple times in the past on this case, and has been cited by the Court of Appeals multiple times in the past as to this particular case. The OPC is simply asking the commission to affirm its prior decisions that no NOL existed. And because no NOL existed, there is no normalization violation, even under the plain ruling provided in the the IRS's private letter ruling. With that, I'd ask if there are any questions, and thank the commission for their time.
Thank you. Are there any commissioner questions for Mr. Kleiser? All right, hearing none. Let's move on to our witnesses. Our first witness is Brian LeGrand. Mr. LeGrand, let me swear you in, and then I'll turn you over to Mr. Cooper. Mr. LeGrand, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes, I do.
Thank you. And Mr. Cooper?
Judge, before I start with Mr. LeGrand, and before I forget this, we had talked about the stipulation of facts and marking that as an exhibit. I would like to mark the stipulation of facts that was filed in this case by the parties as exhibit number 100 for identification.
Thank you.
And with that, I would like to offer the stipulation of facts.
Are there any objections to the admittance of exhibit 100, the jointly filed stipulation of facts? Mr. Kleiser?
No objection.
Mr. Johnson?
No objection.
Without objection, it is so admitted. Mr. Cooper?
We will mark the direct testimony of Brian W. LeGrand as exhibit number 101.
So marked.
With that, Mr. LeGrand, would you state your full name for us?
Yes, Brian W. LeGrand,
By whom are you employed, in what capacity?
Missouri American Water. I'm the Director of Rates.
Have you caused to be prepared for the purposes of this proceeding certain direct testimony in question and answer form?
Yes, I have.
Is it your understanding that that testimony has been marked as exhibit 101 for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
No, I do not.
If I were to ask you the questions which are contained in exhibit 101 today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, with that, I would offer exhibit 101 into evidence and tender Mr. LeGrand for cross-examination.
Thank you. Are there any objections to the admittance of exhibit 101 to the hearing record? Mr. Kleiser?
No objections.
Mr. Johnson?
No objections.
Without objection, it is so admitted, and the witness has been tendered according to the pre-approved and jointly filed schedule. Cross will start with staff. Mr. Johnson?
I have no questions. Thank you, Judge.
And Mr. Kleiser?
I have no questions either. Thank you, Judge.
Are there any commissioner questions? Hearing none, let's proceed to the next witness, I believe that is John Wildy. Mr. Wildy, if you could unmute yourself and I will swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And Mr. Cooper, your witness.
Thank you, Your Honor. We will be marking, or would like to mark, I guess I should say, Mr. Wildy's direct testimony, confidential version 102C, and the public version of his direct testimony as 102P.
Mr. Cooper, let's hold on. I am getting a notification we're having some audio issues.
Okay.
Everyone could please be patient for a second. I will check with tech. Okay, we're going to go ahead and forge ahead while they fix that, if they're, or check on that rather, because we do have the court reporter here. So Mr. Cooper, let's go ahead with your direct.
Okay, we're in the process, I think, Your Honor, of marking some testimony here. And we were going to mark Mr. Wildy's direct testimony, confidential and public, as 102C and 102P. I think you're muted, Your Honor.
You, sir. It was so marked, and you're getting ready to question your witness.
Well, I've got rebuttal testimony as well. I apologize. I have then rebuttal testimony for Mr. Wildy would be 103C and 103P, confidential and public versions.
All right, that is so marked.
Mr. Wildy, would you state your full name for the record?
Yes, it's John R. Wildy, W-I-L-D-E.
And by whom are you employed and in what capacity?
American Water Services Company in the capacity of VP of Tax, and I represent Missouri American amongst the other utilities that American Water holds.
Have you caused to be prepared for the purposes of this proceeding certain direct and rebuttal testimony in question and answer form?
Yes,
Is it your understanding that that testimony has been marked as exhibits 102 and 103 in both confidential and public versions?
I do understand that, yes.
Do you have any changes that you would like to make to that testimony at this time?
Not at this time, no.
If I were to ask you the questions which are contained in exhibits 102 C and P and 103 C and P today, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Your Honor, I would offer at this time exhibits 102C, 102P, 103C, and 103P into evidence.
Thank you. Are there any objections to the mentioned exhibits 102 and 103, both the confidential and public versions of each. Mr. Kleiser, any objections?
No, Your Honor.
Thank you. Mr. Johnson.
No objections. Thank you, Judge.
Without objection, exhibit 102, confidential and public, and exhibit 103, confidential and public, are admitted onto the hearing record. Mr. Cooper.
Thank you, Your Honor. We would tender Mr. Wildy for cross-examination.
Thank you. And Mr. Johnson, your witness. Oh, I'm sorry, go ahead.
I have no questions. Thank you, Judge.
Thank you. And Mr. Kleiser.
Thank you, Your Honor. I'm going to ask for the court to give a little patience here as I'm going to try and present an exhibit. So this will be the first time I've done this in this format. But before that, good afternoon, Mr. Wilder. How do you pronounce your name?
Wildy.
Wildy. I apologize. It's not my intention. All right. Your Honor, I am currently attempting to send an exhibit to opposing counsel and yourself.
Okay.
Give me 1 second. I apologize. And I should note that this is a confidential, or rather an exhibit that would contain confidential information.
All right.
Should I, Mr. Cooper, would it be better that I send it directly to the witness, or would you prefer to forward it to the witness yourself? I'm not sure that I have the witness's email address.
Yeah, if you send it to me, Mr. Kleiser, I'll forward.
All right, I have sent that email, and I'm waiting for receipt. Would opposing counsel and/or the judge please identify whether or not they receive a copy?
Just received it.
I have not yet, but
Forwarding now.
oh, there, I have received it.
I've received it as well.
All right, with that, I believe I'm ready to proceed, unless Your Honor would say differently.
Mr. Kleiser,
I'm sorry, go ahead.
I have not yet been able to forward it, so if you give me just.
Oh, of course.
Okay, I have forwarded it, so don't know whether Mr. Wildy has received it yet or not.
I have not received it yet. I'm looking.
Mr. Kleiser, do you have questions that we could start with that maybe aren't on the exhibit while that makes its way through the interwebs?
Actually, if I probably won't.
Okay, fair enough. Oh, hold on just a minute. Bev, hold on. I can't hear you.
Okay, for some reason, I have lost the Bluetooth connection with my steno machine. And so I guess I'm gonna have to get out of my file and then get back in, and I'll let you know when I'm ready.
That's not a problem. We'll wait for you,
Okay.
Bev.
Okay, thank you.
Okay, just in case anybody didn't catch that, our court reporter was having some technical difficulties. She is going to fix those. I would advise everybody to mute and hold the line. Hopefully it'll be just a minute or two.
Testing 1, 2, testing 1, 2.
With that, I believe I'm ready to proceed, unless Your Honor would say differently.
Testing 1, 2. Judge, I think I'm ready to go.
See Mr. Cooper come back. Everyone, our court reporter says that she is reconnected and ready to go.
The problem is the
And-
witness hasn't received his, I haven't received that file yet.
Okay, well, we're still waiting then.
Mr. Cooper, are you there?
He's muted, Mr. Yeah.
There we go. I am.
If you've taken a look at the exhibit, I think you'll appreciate that it's a DR response the OPC received from the company. I don't know if this will help, but if the company is willing to stipulate to the admission of the exhibit, then I can forego any further questioning.
That's probably where we will be, but gosh, I'd like for Mr. Wildy to at least be able to see it before I did that.
Could you try sending it again?
Yes, I will.
Or send it to Brian as well and have Brian forward it? Maybe it's
Brian-
internal.
Yeah, I did send it to Brian at the same time, so.
Mr. Cooper, Mr. Kleiser, and Mr. Johnson, I have a proposal. While we wait for Mr. Wildy to get the email, would it be all right if we go ahead and go to commissioner questions? And then we can come, well, no, let's go ahead and wait for Mr. Wildy to look over his exhibit. That sounds better.
Okay, I was going to add that I would actually be okay with that.
Mr. Wildy, any update on your email?
No, I'm getting other emails, so it's not like email shut down.
Okay.
Here, I'm going to try something different, Your Honor. Mr. LeGrand has access to our DR responses, obviously, so let me. point that out to him.
Well, if you just tell me what DI response it is, I can look that up as well.
It's going to be OPC DR 1400.
It will
1400?
also be,
1300.
I would add it's specifically attachment 3 that was provided.
I'll try to find it that way while.
Okay, Mr. Cooper, Mr. Johnson, do either of you have any objections to my going ahead with commissioner questions? I do have a few.
I have no objection.
I have no objection either. I take it that means that these are Mr. Kleiser's only questions for Mr. Wildy.
I did receive the file now.
Oh, then, well, let's stop the train. Mr. Kleiser, let's go ahead. We'll give Mr. Wildy a few minutes to look over and get familiar. And then Mr. Kleiser, please start your cross exam.
Does Mr. Wiley believe he has looked over them sufficiently?
Yes.
And can you please identify, without divulging any confidential information, what the item in question is?
It's a schedule, one of the schedules that you prepare with respect to submitting a tax return via e-file to the IRS for 2018.
And this is a bit awkward because I'm not sure if it's what I've actually sent you, but is the exhibit a true and accurate copy of what was sent to the OPC in response to the data request the OPC provided to the company?
It's part of, yes, part of a response. It's part of the tax return we sent in. It's form, what I have on my screen is form 8453-C.
Let me just double check that we're talking about the same thing here.
And there's extra pages, so it's actually, the tax return also is attached.
Mr. Wildy, if you could hold on just a minute. Bev, I'll unmute you. Yes, ma'am. No, go ahead. Bev, I didn't hear that.
I said Mr. Wildy's answer was muffled.
Mr.
I
Wildy,
apologize.
thank you. He's a little closer to the mic. Go ahead with your answer.
It is the tax return filed for 2018.
All right, at this point, I'm just going to try and move things along. I would ask that this be marked as OPC Exhibit 200 and offer it.
Right. Are there any objections to the admittance of Exhibit 200? Mr. Kleiser, was there a public version of that as well?
Not to my knowledge, unfortunately.
Okay, so just Exhibit 200, the confidential version. Are there any objections, Mr. Cooper?
No, Your Honor.
Any objections, Mr. Johnson?
No, Judge.
Then Exhibit 200, confidential without objection, is so admitted onto the hearing record. And Mr. Kleiser?
That actually concludes this exhibit in a cross of a later staff witness, but needed this witness to identify the foundation for it. So having been admitted, I have no further cross. Thank you.
Thank you, Mr. Kleiser. As promised, I did have some questions from the bench. First, Mr. Wildy, can you walk me through and describe the process for Missouri American requesting a private letter ruling from the IRS?
Sure. The process by which we go through is actually established in, I think it's a revenue procedure. I believe it is. Yes. And
Can you lean a little closer to the microphone?
sure.
A judge?
Yes.
Yeah, and he needs to do something because I'm having a hard time understanding him.
Okay.
So I use call me, and I suppose that's not the best method to do this, or I'm not using my computer, I'm using my phone. Does that help?
No, you sound fine. We were just, I think we were getting some background noise from another connection. Bev,
Okay.
does that work? Is he sounding better now?
Yeah. He said, I'm sure the process by which we go through.
No, the process that a taxpayer goes through to request a private letter ruling is documented in a revenue procedure, which I don't have off the top of my head, but we could provide if the commission would like it. The process is that you indicate to the IRS that you intend to file a private letter ruling submission. The IRS might ask you to provide some preliminary information about the issue that's going to be considered. Then you have the IRS could either seek written guidance from you in terms of what that ruling request might be, or ask you for a pre-submission conference. In this case, they asked for a pre-submission conference. We went to a pre-submission conference. Then we notified, after the IRS told us, yes, we would accept your ruling request. Then we went to the commission, notified them, commission staff of that, and asked them for the necessary participation in that ruling request process to move it forward. Because in the end, the commission, or represented by commission staff, has to represent that the ruling request that we submit is complete and accurate, and we have to represent that we included the staff in that way. Then we make a written submission, and only if the IRS is going to rule in an adverse manner does the IRS ever contact you again before they issue their ruling request. In this case, there is one particular ruling that they rule adversely, so there was a conference. Staff was invited to that, but it wasn't one of the rulings that they were interested in and did not participate. It was ruling 3, and it's not actually one of the rulings that's in question here. So the IRS then, a couple of weeks later, issued its request, or issued its ruling. That's the process.
Thank you. Who submitted the private letter ruling request to the IRS?
It's submitted by the parent and utility itself.
Who drafted it, I guess? Was there an accounting firm?
We hired, yes, we hired Deloitte to represent us. They have a nationally known expert on the normalization rules, is by the name of Dave Yankee. So we chose that firm. There's very few people that have an intimate knowledge with the normalization rules out there. One of them actually passed away just after the TCJA was passed. So there's even fewer of them. So we selected Deloitte, and that's who drafted the ruling request for us.
Okay. Attachment J, and this is the PSC staff's comments regarding Missouri American's request for the private letter ruling. Was Attachment J included with the whole package, or was it sent separately?
It was included with the whole package.
Okay.
Yes. In fact, we actually submitted it in 2 parts, the ruling request in 2 parts, and then made sure that it got aggregated. And we got actually notification back from the IRS that the aggregated copy had made it into the their file. That's typical when you have a large attachment and how the IRS receives it.
So did Missouri American or Deloitte receive some type of acknowledgement that attachment J was received?
We received, yes, any submission, we received a secondary attack notice from the IRS that they received everything. Yes, Deloitte received it, and then they forwarded it to me.
Okay. And to your knowledge, were there any conversations between anyone with Missouri American or its agents like Deloitte throughout the private letter ruling process? Conversations with the IRS?
The only after the ruling request was submitted, the only conversation was the adverse ruling for number 3. That was limited to conversations around ruling number 3. And then there was a subsequent email regarding ruling 3 issued by the company at the request of the IRS, and that was it.
Okay. And I am not an accounting expert, and the private letter ruling was rather dense reading. But my understanding is that it indicates that plant repairs are not subject to accelerated depreciation. Is that correct?
Yes, because you claimed a repair deduction on it, so it's not available to continue to take accelerated depreciation on it.
Okay. Why are the plant repairs treated differently?
It's simply by function of the tax law. So in the normalization rules have their birth in that when for a long time utilities could not take advantage of accelerated tax depreciation because the government felt that by giving them that tax incentive, they would just lower revenues to the federal government and force a subsidy into the customer's rates. So it wouldn't actually do its intended purpose, which was to incentivize the utilities and utility commissions to invest in needed infrastructure. So the intent of the normalization rules is to foster, as an incentive, investment in utility infrastructure. The normalization rules make sure that when the IRS gave the taxpayer and the commission essentially, or the customers, that incentive, that it was preserved as an incentive to investment. And if all you did was turn around the tax benefit right away to customers, it wasn't an incentive to the utility to invest.
Okay.
Hope
And
that makes sense.
what exactly is considered plant repair?
So for book purposes or accounting purposes, they treat, and I always use this analogy, a very small piece of pipe as a capital addition. For tax purposes, they define large. For tax purposes, you define the system more broadly, or the unit of property more broadly. So when book accountants are only replacing
Taking you home, Grouchy Pants.
No,
Then stop. Then stop.
I'm sorry.
Mr. Wildy, could you start that answer over again, please?
Sure. That happens in these cases. So can you ask the question again? And it's really...
Yes. My question was, can you tell me what is considered, quote, plant repair, close quote?
Sure. So a tax repair is where the tax unit of property is defined larger than the book unit of property, allowing for when you actually just replace it, the smaller book unit of property, that it's not considered a capital addition for tax purposes, and you get to deduct it currently.
So then there wouldn't be the same concern of a normalization violation for repairs completed and included in the ISRIS. Is that correct?
There's not a normalization issue because it's not a defined protected item pursuant to those tax rules.
Can you tell me why is it that plant repairs are deducted in the ISRIS calculation of deferred taxes? And I'm referring to your Schedule 2 on your pre-filed testimony. Or I'm sorry, on Mr. LeGrand's testimony.
So just as a clarification too, they're deducted, and the effect of those deductions are included in rate base as well. So they're deducted to compute the loss, and
please leave a message or try me in my office at area code 573-751-4132.
Sorry, Mr. Wildy, can you start over? I can see our court reporter getting ready to ask.
No problem. So I believe the question again was to explain why there's repairs on ISRIS property. Again, I believe the statute for what's in ISRIS is property within St. Louis County that is replacement property. So we're dealing with a replacement of existing pipe, and to the extent, and it's not all property that you replace gets a repair. Only some does. Only some qualify as a repair pursuant to the tax rules. Not every single capital addition you make for plant is qualified as a tax repair. So you do a facts and circumstances determination to determine whether the property would qualify for repair. And there's estimations made to do that in this case. But again, it's replacement property, so that would be one consideration. It's not new property, it's replacement. Number two is the replacement is for tax purposes of something less than a unit of property for tax purposes, but is a book addition. That answer your question?
Thank you. Can you describe for the record what are contributions in aid of construction?
Sure. There's situations where, in these cases, it looked like to me like a lot of cases where relocations are being requested, and there's a replacement of existing property, and in these cases that you would get funded by someone else, may it be a government, so they contribute to the construction of the property for book purposes. So let's say that I have to put $1 worth of property in, and it's for the benefit of only one customer or for a specific purpose. We would go to that one customer or that governmental agency and say, we're doing this on your behalf. It's not for the benefit of the overall customer base, and we would collect a contribution aid to construction pursuant to commission rule.
And how are the contributions in aid of construction included in Missouri American's ISRIS calculation?
They're included as, it would be included as from the tax part of the ISRIS, or from the book part, because Brian LeGrand might be the best person to answer the contribute. So are you asking from how are they included in my tax calculations, or are you asking?
Hold on just a minute, Mr. Wildy. Hold on just a minute, Bev.
I'm so sorry, but Mr. Wildy was cutting out on that answer for me.
Apologize.
Judge, can I ask the question again and have him start again?
Yes, please go ahead.
Okay, and how are the contributions in aid of construction included in Missouri American's ISRIS calculations?
And I believe I asked the hearing examiner if he was seeking that question from a perspective of an overall answer or specific to just the tax component.
Overall, because I believe what Missouri American is contemplating is this net operating loss started from the moment a pipe was purchased up until the moment that the ISRIS rates are put into effect. So you're trying to calculate a net operating loss just for that period. So our contributions in aid of construction in that calculation, and how are they in that calculation?
So they would be, from perspective of calculating the loss, they would be part of the tax deductions and part of the accelerated depreciation deduction that you would calculate for the utility itself. A lot of companies separate them into two, but the IRS, pursuant to rules that they've issued, treat that as one single book tax difference.
Okay,
So
is that the same?
So from a loss perspective, contribution in aid of construction would be income or a contra deduction.
Is that the same way that contributions in aid of construction is treated by Missouri American in its annual report?
No, for financial accounting purposes, a contribution in aid of construction, when it's received, is simply used to reduce overall plant or overall rate. I mean, you accrue the contribution in aid of construction as a liability for book purposes. You accrue the plant separately for water companies. Electric and gas utilities would net the two in plant. Water companies keep a separate liability. So there would be a liability to customers for that contribution in construction. But for tax purposes, that would not be treated as a liability.
Okay, and I want to turn for a second to ruling 8. Can you explain why Missouri American submitted the request for this particular IRS ruling?
So throughout this proceedings, we've cited two positions. The first position is that on a separate incremental basis, the ISRIS produces a loss. When you take into account the income that the ISRIS property is generating at the time, less the tax deductions that you are claiming at that particular time, arrive at a taxable loss on a standalone incremental basis. Others then argued that no, you have to look at this more at an aggregate level. And IRS, even though the taxpayer, American Water, did not think that's how the IRS would look at the NOL, we said, well, then you have to then consider the NOLC that's there as an incremental deduction available to you during the period, because it's a deduction available to you. So if you look at a particular tax return, an NOL is an available deduction at the bottom of that tax return to arrive at taxable income. The commission decided to do an aggregate approach and without respecting the NOLC. So without treating the NOLC as deductions available to the company, they calculated a loss. We said, I don't think the IRS is going to, we said, we don't think the IRS is going to rule that way. So if you look at 8, 9, and 10, what do? 8 is just supports we call the consistency rules of the tax normalization rules. And 8's just a different way of looking at 9 and 10. The IRS concluded by ruling in 9 that they're looking at the incremental interest, not at anything in aggregate. They said, but they did provide analysis pointing that if they had ruled on 10, they would consider the NLC as a relevant fact. So if you read the ruling request, that's why 8, 9, and 10 exist. 8 just adds on that says, from a perspective of how much deferred, so there's consistency, right? So the same, when you're setting that rate, this being the interest rate, the rate base that you're talking about is the same, is the source of the deductions that you're talking about and the aided that you're talking about. And there's no deferral that can be inferred throughout that process. So if you look at the tax guidance or things that are cited in there, the IRS will start to talk about, was there a deferral or was any of the accelerated depreciation tax deductions deferred by virtue of an NOL? And again, our argument is consistently said that when you look at this on an incremental basis, yes, there's a loss. When you add up repair deductions, accelerated tax depreciation, even if you include kayak, there's $39.6 million of losses in that, of deductions available to the company in that year that's cited in that fact, and there's no income on an incremental basis that's coming through. If you add in contribution aided construction of $1 million, you still have $38 million loss. But the IRS doesn't say that you have to include a $38 million loss. They say you only have to include the loss related to accelerated depreciation. So then they tell you to do a with and without test. And that's what we did to come up with the $35,000. We figured out the portion that was related to just accelerated depreciation.
Okay, and
hopefully that reporter, did I speak loud enough?
I'm doing my best. It's very difficult.
I'm sorry. I'll hold the phone up even further to my face.
Okay, last question from me. And Mr. Cooper, heads up. Mr. Wildy, please don't answer for a second after I ask the question because it may touch on some confidential information. And I'm looking to Mr. Cooper to see if he has any objections. How would you address the concerns raised by Mr. Oligschlager in his rebuttal testimony about any future application of Ruling 8 and what the meaning of, quote, recovered in rates, end quote, in Ruling 8 signifies?
Your Honor, I think that's all a part of essentially the public version of that private letter ruling. So I think we're okay.
Okay. Mr. Wildy?
So again, I think it just supports ruling 8 and 9 or 9 and 10. So if you looked at it from an aggregate perspective, and Mr. Oligschlager actually admits in several versions of his testimony in these past districts is that this commission and he himself has allowed NOLCs to be included. So I don't believe ruling 8 expands that application of the law at all. If there's an NOLC at the beginning and end of year, then you must calculate how much of that NOLC that exists is protected pursuant to the normalization rules and include that in rate base, regardless of whether and it just really supports it that it hasn't accrued through the deferred tax expense calculation. I think if you read, so Mr. Oligschlager quotes a section from his own writing that says, hey, we're looking at revenues from the future before we'll let you book a deferred tax. That's really not the case. We're looking at the revenues available to the company as of the date of the measurement and the deductions that are claimed. So unless you have an NOL fee that you're carrying, you're not limited for the deductions you can take. So all we're asking is what this commission's historically done in the past is to put an NOLC where it belongs. The ISRIS, I understand, is a more complicated issue in that revenues are kind of generated. You don't really, in that first year of an ISRIS, you haven't yet collected any rates regarding that property or prior property. But in a rate case, you are able to put those deferred taxes through the provision, except for if it's deferred because of an LLC. So I don't think there's any big change.
Okay, thank you, Mr. Wildy. We are at commissioner questions, and I took the lead on that. Are there any other commissioner questions? Okay, hearing none, we return to recross. First is Mr. Johnson for staff.
Judge, I don't believe I have any questions. Thank you.
Thank you. And Mr. Kleiser.
There was certainly a lot of ground that was just covered there. I'm going to try and keep this short. Mr. Wildy, help me out. When the company calculated the net operating loss that it is claiming is necessary to correct for in these cases, for the previous 3 ISRIS cases, effectively what the company did is it took accelerated depreciation expense and offset that against a revenue of $0. Is that correct?
That's the short math that happened, but that's not consistent necessarily with. We tried to do it in the simplest manner that was possible to get to the right answer, but
it is $0 of revenue offset because, I mean, again, the company's position has always been they have no revenues when this pipe is put in the ground. And accelerated depreciation expense is what's being offset against that.
We considered the revenue that was collected from pursuant to the ISRIS at that point in time in the ISRIS. We considered the repair deductions for purposes of the overall loss. We considered the kayak income. We considered the accelerated depreciation loss deductions. Those together produce an NOL. Then we applied the with and without test. Did we do the long math for that, and then deal with the contribution aid to construction DTA perfectly? No, but if you did we did those things, you wouldn't get to a different answer than the $35,000. It's just a different way of calculating it.
What was the total net operating loss the company came up with for the 3 cases that's attempting to correct for here?
I don't have that calculation in front of me, and we didn't submit that calculation. Because again, but I think if you look at the revenue requirement for the 3 cases, and you look at the deductions that were submitted, you could calculate that, and it would be a loss.
I don't think I'm going to get anywhere with you, so I'll just let it go. Thank you. I have no further questions.
Thank you, Mr. Kleiser. We come now to redirect Mr. Cooper.
Thank you, Your Honor. Mr. Wildy, there was questions about the repairs allowance piece of this, and just to kind of provide some context for it. In the 3 prior ISRIS cases, the company, when it proposed an NOL, would it be accurate to say that that NOL was built upon both the impact of accelerated depreciation and the repairs allowance?
Yes, the 39.6 million would have both numbers in it, but again, the loss is not just simply the loss. You have to provide the with and without test.
But here's where I want to go.
With that route.
Here's where I want to go with that. In the private letter ruling, and both myself and I think Mr. Johnson, counsel for staff, noted that the private letter ruling indicated that there was a normalization violation in regard to the accelerated depreciation piece, correct?
Yes,
But did not so indicate that there was a normalization violation as to the repairs allowance piece, correct?
that's correct.
So the adjustment that's being proposed in this case by the company is based solely upon the accelerated depreciation side of things and does not include the repair allowance, correct?
No, it would not it would not include the repair allowance because it wouldn't attribute any loss to the under the with and without test. It wouldn't attribute any loss to the repair allowance.
And the PLR told you how to separate out the repair allowance and that would not be included here, correct?
It told you to apply the with and without test. It said, look at the loss, and it cited what loss to look at, and then it cited to apply the with and without test.
So here's where I'm going. In the prior three cases, there was a much larger revenue requirement at issue in those cases as well than the adjustment that's being proposed here as a cure, correct?
That's correct.
And that's a function of the private letter ruling, correct?
That's correct.
You were asked questions about the impact of SEAC, and I know you said that Mr. LeGrand does those calculations, but to the extent you are familiar with this calculation, in the deferred taxes calculation in this case and the two prior cases, is there a line item for taxable income contributions that's taken into account by the company?
If you look at the tax calculation, you'll see the contribution aid of construction taxable income reconciled in the for 18 and 19. You'll see it there done that way.
In 20 as well?
In 20 as well.
You were asked some questions about the impact of ruling 8. Do you remember that?
Yes.
For purposes of the adjustment that's being proposed by the company in this case, is ruling 9 sufficient to justify that adjustment?
Yes.
And if based upon ruling 9, you make that adjustment, there's no need to treat ruling 8, is there?
No.
In answer to one of the questions, you made a comment that that the reflection of the NOLC was being done like the commission had done in the past, I think. Do you remember that?
Say that again.
Yeah, I think you made a statement that you were wanting the net operating loss carry forward, the NOLC, to be reflected here like the commission had reflected it in the past. Does that sound familiar?
I don't think I used those exact words, but yes, what's the question?
Well, any reference you make to prior reflection of an NOLC in rate making by this commission would be in reference to a general rate case, correct?
Right. What I'm saying is how 8 would apply in a general rate case, because I was asked if it had impact on a general rate case. I would say then you would you would look at the IRS's analysis in this ruling regarding ruling 10, which they didn't go in detail, but they did provide analysis. They didn't provide a ruling, but they provided analysis and factual. And essentially that ruling said, if but for 9 in an ISRIS proceeding, in a 10, if you looked at this ISRIS more on an aggregate basis, you'd have to look at the NOLC. But again, Mr. Oligschlager has indicated repeatedly in these cases that if there's an NOLC at the end of the thing, they generally do include the NOLC in the rate base calculation.
You were asked some questions by Mr. Kleiser about the income that was considered in the company's tax calculation. And he asked you whether 0 was the amount of income considered, I think, generally. Do you remember that?
Say that again.
So Mr. Kleiser was asking you about what, I guess I said income, revenues were considered as a part of the company's tax calculation, correct?
We use the same revenue consideration as what would have been used by Mr. LeGrand in the calculation of, as a consistency perspective, of what he would have consumed as the revenues available to the company as of the measurement date. Again, the IRS does use does make the mention that it's the revenue as of the, or not the revenue necessarily, but the income, taxable income available to the company as of the measurement date of rate base.
So here we're talking about a series of 4 cases, correct?
Sorry. I'm sorry,
Correct.
Mr. Cooper, I missed the end of his statement. He said, and I believe income available to the company.
So yes, we would have based it on the income available to the company based as of the measurement date of the ISRIS rate base.
And because this is a series of, so far, 4 ISRIS cases, when you're in cases 2, 3, and 4, there are ISRIS revenues to be taken into account, correct?
That's correct.
That's all the questions I have, Your Honor. Thank you.
Thank you. Pause for a second and note that it is 5 to 3. We have been in this hearing for approximately 2 hours. We finished 2 witnesses. We have 4 to go. I'd like to check in with counsel about taking a break. And I'd also like to look to my court reporter to see if she would like to take a break. I'll start with the counsel and I'll let the court reporter nod or shake her head. Mr. Cooper, what do you think about taking a 10-minute break now?
I would not object.
Do you have any thoughts about how long the examination of the next 4 witnesses might go?
Yeah, I don't know. I think Mr. Johnson may be in a better position to address some of that, but I think a couple of the witnesses at least may move pretty quickly.
Okay, thank you. Mr. Kleiser.
I do not object to a break and would prefer a break. I do not expect that either all.
Sorry about that, Mr. Kleiser. I muted you on accident. Mr. Kleiser, go ahead.
I do not expect that either Ali Arabian or Matthew Barnes will have significant cross and would therefore go quickly. I cannot speak as to the other 2.
Okay, and Mr. Johnson.
I do not object to a break, and from my standpoint, I do not anticipate having any substantial cross.
Let's take 10 minutes. We'll have an intermission, stretch our legs, I'm going to call this 3 o'clock, even though it's 3 till. So 3:10. 10 after 3 is when we will resume. And I will mute the audio stream and put the live stream intermission sign up. Thank you all. See you at 3:10. His testimony. Mr. Riley, if you would please unmute yourself and I will swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
So help me God.
Thank you. And Mr. Kleiser, your witness.
Mr. Riley?
Yes, sir.
I would suggest that you mute your computer. You're producing some feedback.
Okay.
Mr. Riley, can you please state and spell your name for the record?
John S. Riley.
All right.
PO Box 2230. Excuse me.
By whom are you employed and in what capacity?
I've lost.
Mr. Riley, I believe that you've hit the share content button at the bottom.
Okay, hold on.
You're already in the, Mr. Riley, you're already in the meeting.
I know I hit the button and I'm not sure how to. There we go.
There you go.
Okay.
You know what, Judge? There's all kinds of feedback on him.
Yeah, I'm hearing that too. Mr. Riley, are you listening to audio at your site? I think you are, because I'm hearing through. Okay, I'll give it a testing 1, 2.
Well, I'm trying to, hopefully this, can you hear me? Still hear me?
Yes, we can hear you fine. I think the volume has now gone down. What was happening was like a radio call-in show. If you're listening in the background, it's going to be transmitted a few seconds later, again over the live feed.
Okay.
Okay, I'm going to give it a testing 1, 2.
1, 2, 3.
Well, I'm still hearing it on my end. Bev, are you still hearing feedback? Yeah.
I'm not sure how to get rid of it. Should I mute it and call you?
Computer.
But if I mute the computer, you won't hear me.
Just call
Mr.
in.
Riley, can you call in from your phone and just skip the computer part?
Yeah, I'll do that.
All right.
Does that work?
Yes, I think it does. Perfect. Mr. Kleiser, please go ahead.
All right.
Hold
Since
on,
we've had
just a second.
such
Mr. Kleiser,
Yes.
the only question that I got was when you asked him to please state and spell his name for the record.
My intention was to just start over.
Thank you.
Thank you. Go ahead.
As I was saying, because we've had such difficulties, I'm just going to start again at the top. Mr. Riley, can you please state and spell your name for the record?
John S. Riley, R-I-L-E-Y.
By whom are you employed and in what capacity?
I'm employed by the Missouri Office of Public Counsel, the Public Utility Accountant 3.
Have you prepared or caused to be prepared testimony for today? Direct testimony in this case.
Yes, I have.
Have you also prepared or caused to be prepared rebuttal testimony for this case?
Yes, I have.
With regard to your direct testimony, do you have any changes?
I have one change.
And what would that be?
Page 8. On page 8, line 3, the pre-tax incremental revenues would then be, the correct number should be $9,684,158. 9684158.
Thank you. You said that was your only change to the direct testimony, correct?
Yes, sir.
Are there any changes that needed to be made to the rebuttal testimony?
Just one.
Oh,
Okay, page 8, line 9. Should read, it reads, with shortened schedule, I was not been provided a copy. Should read, I had not been provided a copy. So remove the was and replace it with a had.
had you also prepared an amendment to your rebuttal that was
Yes,
intended
sir.
to correct mistakes?
Yes, sir.
And those were, again, also intended to correct a mistake or error or omission in the rebuttal testimony?
Yes, sir, in rebuttal.
All right. In light of the one change that you just identified and the amendments that you filed, are there any other changes to the rebuttal?
No, sir.
All right. Your Honor, I'm going to offer Mr. Riley's direct, which should be, if my recollection is correct, OPC Exhibit 201. Mr. Riley's rebuttal, which, if my recollection is correct, should be OPC Exhibit 202. And the amendment to Mr. Riley's rebuttal as OPC Exhibit 203.
Okay. I'm going to take them all as a group. Mr. Cooper, do you have any objections to the admittance of those three exhibits?
I do not.
Mr. Johnson, do you have any objections to the exhibits?
No objection.
Without objection, all three exhibits, both confidential and public versions, are entered into the hearing record. Mr. Kleiser, go ahead.
You have reminded me, Judge, I was intending originally to ask that Exhibit 201, the direct testimony, actually be marked as solely public, following the decision regarding the confidentiality of the public version of the private letter ruling. I'll just leave it at the Commission's discretion whether or not it feels that is beneficial to have that marked as public or not.
No, I prefer to take care of that here. Mr. Cooper, do you have any objections to Mr. Kleiser's suggestion?
I don't know that I can respond right now without going back through that testimony section by section, Judge. I don't mind doing that, but I don't think I can do it on the spot here.
Okay. Let me think about that, Mr. Kleiser, how I want to handle that. Go ahead with your examination.
I have completed my examination and I tender the witness for cross.
All right, thank you. First, we have Mr. Johnson.
I have no questions, Judge.
And Missouri American.
Thank you, Your Honor. Mr. Riley, in your rebuttal testimony, you indicate that Missouri American failed to consider SEAC in its net operating loss calculation, correct?
Yes, sir.
Let's turn for a minute to your amendment to rebuttal testimony and the schedule JSR AR-1. Do you have that in front of you?
Yes, sir.
And if you will turn to page 4 of 8 within that schedule. Are you there?
Yes, sir.
And that's a page that says Missouri American ISRIS number 18, deferred taxes, correct?
That's correct.
And do you see on line 30 that there's a line for taxable income contributions?
Yes, sir.
Okay. Let's turn over to page 6 of 8 in that same schedule. And that is, again, titled Missouri American and now ISRIS 19, deferred taxes, correct?
Yes, sir.
And on line 30, again, there's a line, taxable income contributions, correct?
That's correct, sir.
And then if we turn to page 8 of 8 in that same schedule, again, have Missouri American ISRIS number 20, deferred taxes, correct?
That's correct, sir.
And again, line 30 is taxable income contributions, correct?
That's what it says, yes.
Okay. You also allege in your rebuttal testimony that the private letter ruling does not contemplate the existence of ongoing revenues related to the pipes in question arising from the sale of water flowing through those pipes. Is that a correct statement?
I think so, yes.
And now you would agree with me, wouldn't you? And I quoted this language in my opening, but you would agree with me, wouldn't you, that the private letter ruling recognizes that in this case, the parent on a consolidated basis and the taxpayer, which would be MAWC, on a separate company basis, estimate that taxable income was earned and thus NOLC was utilized. You remember that?
Not really, but go ahead.
Well, do you have Mr. Wildy's direct in front of you?
Yes, sir.
And if you go to schedule JRW-2, which is the private ruling, correct?
Yeah, I don't have the schedules up. But,
You don't have the schedules? Okay. If the IRS knew or repeated the fact that there would be taxable income in this case, 2018, they clearly knew there were revenues other than those from ISRIS, correct?
You want to repeat your question again, sir?
I guess my question is really in the PLR, it's contemplated, isn't it, that the company has net operating income in 2018?
I'm not quite sure if they contemplated that or not. I've spent more time studying the 12 questions.
Okay, let's try this.
The company would have. I don't think that. I don't recall the IRS making any statement about it.
Mr. Riley, could you start again?
Yes. Okay. I said as far as the private letter ruling goes, I'm not quite sure what the IRS determined as far as net income goes. I
But
don't
in the
recall
end,
them ever met.
go ahead. In the end, the language of the private letter ruling, and I suppose the language of the request would tell us what was indicated in regard to net operating income as far as 2018, correct?
Sir, I'm not following your line of questioning. The private letter ruling discussed net operating losses within a surcharge.
But you don't remember, or you don't have the private letter ruling in front of you, do you?
Well, I do. I have a copy of it. It's just not Mr. Wildy's exhibit. Well, I correct myself. It is Mr. Wildy.
So within the exhibit, will you turn to page 7 of 23?
I'm there.
And in the middle of the page, there's a paragraph that starts on a consolidated basis. Do you see that?
I see that.
And at the end of that paragraph, there's a sentence that says, I believe this is public because it's part of the public version. For year 2, comma, parent on a consolidated basis and taxpayer on a separate company basis estimate that taxable income was earned and thus NOLC was utilized, correct?
Okay, that's correct. Yes, sir.
Now, when you talk about the PLR does not contemplate the existence of ongoing revenue, I assume you're talking about revenues from the base rates for Missouri American, correct?
Well, the company didn't mention any other revenues.
What revenues? Well, we just talked about the fact that the company identified net operating income in the year in question, but I want to know what you're talking about when you talk about the existence of ongoing revenue.
Well,
is it the base rates?
The argument that Missouri American has brought up is that prior to the ISRIS rates going into effect, they don't have any revenues to offset the accelerated depreciation in this case, in this ISRIS case. And the accelerated depreciation represents the net operating loss that they're claiming in this case. Because no ISRIS rate making has any revenues when they put the pipe in the ground.
But the only other revenues that you could be referring to are those revenues that come from the company's base rates, correct?
Correct.
And those would be the revenues that are the result of rates that were set in Missouri American's last general rate case, WR 2017-0285.
You know, I would think that in the other 3 ISRIS cases, I guess, rates go forward.
And if we talk about the rates, the base rates, the ones that were set in WR 2017-0285, would you agree that they were based on a true-up period ending December 31st of 2017?
Which case?
WR 2017-0285, the company's last general rate case.
Okay, yeah. I'll take your word for it that there was a true-up.
And does that sound right, December 31, 2017?
I have to take your word for it. I'm not sure.
But let's go about it this way. Whatever the true-up date was, the rates set in that case would only have contemplated plant in service or plant that was placed in service prior to the true update, correct?
That I believe is correct.
And Missouri Americans ISRIS, of course, it only applies to ISRIS eligible plant put into place in St. Louis County, correct?
You kind of broke up there. I'm sorry.
Sorry. MAW's ISRIS only applies to ISRIS eligible plant in St. Louis County, correct?
Well, I guess it's St. Louis County, but ISRIS case, the only thing that's eligible is the ISRIS related plant. I'll assume it's in St. Louis County.
Well, the ISRIS is all, the statute only allows for St. Louis County anyway, correct?
I'm thinking so, yes.
Do you know how much non-ISRIS eligible plant Missouri American has placed in service in St. Louis County since the true up in its last general rate case?
No, I do not.
And you probably don't either know how much plant Missouri American has placed in service around the state since that true up date either, do you?
No.
That's all the questions I have for now, Your Honor.
Thank you. The bench has a couple questions for Mr. Riley. Mr. Riley, is a net operating loss only a tax item, or is it also a regulatory item?
It is my understanding that the net operating loss, which is a tax return item, is included in rate-making procedures.
Okay. And if I understand your testimony, you calculated a net operating loss for the ISRIS periods at issue. Is my understanding correct?
Well, I wouldn't say I actually calculated it. I took the calculations from the company on their exhibits and pulled those out and listed them in my testimony.
And you listed them as, labeled them as a net operating loss. You had listed a kayak for each of the 4 ISRIS cases, and then a net operating loss for each of those 4, which then I took one step further and I could calculate whether each particular ISRIS period had a loss or not. Can you explain to me the distinction you're making that a net operating loss is only a tax return item?
Well, what the company has done, because an ISRIS is a prospective rate-making feature, they have claimed a lack of income as an income recognition to claim a net operating loss, which is a tax return item, which is why we have the IRS involved in this. What I have actually said is if you're going to pull out your accelerated depreciation and claim a loss on that because you don't have any revenues, I point to SEAC as a revenue that is clearly within the ISRIS period because they actually calculated it in their exhibits and schedules. And now that since the Tax Act has been enacted, SEAC is now a taxable income, then I place the SEAC in the same category as the net operating loss. Both of them are tax return items for rate making. SEAC is actually a deduction from rate base, but as far as apples and apples, the tax return items, those two should be matched.
Okay, and I think this is my last question. Your testimony and a lot of the public counsel's arguments are based on the fact or the reading of the commission decisions in these previous ISRIS cases that the commission found there was no net operating loss. Would your analysis change if I changed the wording of that to be the commission found that Missouri American didn't provide sufficient evidence of a net operating loss during that period? Would that allow you to then agree that there could be a net operating loss within that period and now it's a matter of calculations?
No, I'm sorry. I couldn't, I believe that a net operating loss is a tax return item which requires a tax return completed. I don't believe that you can have a net operating loss on an interim basis. And they also didn't have net operating losses on their last two tax returns. So I'm not sure if you're changing the wording would change my opinion of it. I don't see a net operating loss anyway around this.
Okay, so as I understood your testimony, then kind of the first point in your testimony was, and I'm summarizing, that the PLR is basically meaningless because the IRS assumed the facts that there was a net operating loss and just went from there. Second, if the commission, you don't believe that, I would argue that the company didn't include kayak, and that should be included in order to come up with the number. And then third is the company hasn't correctly included all of the revenues. For example, revenues that start when the pipe is placed in service and water is running through it, even though those revenues are from the previous case. Am I summarizing that testimony fairly?
I think you did a very good job of summarizing that.
Okay, then are you saying that the private letter ruling that contemplates net operating loss occurring within a short ISRIS time period is incorrect because it is only a tax return item and could not be calculated for a shorter period?
Well, yes, I believe that. Well, they didn't have a net operating loss for the entire year, so I think it would be hard to say that there's a net operating loss for an interim period also. But all the publications that I've read in the IRS website all indicate in order to claim a net operating loss, you have to file a tax return. So to claim a net operating loss because you didn't have revenues prior to the ISRIS rates being set, I don't think that's a correct assumption.
Okay, and I really do mean it this time. I think this is my last question. What? I'm sorry. What? Can you give me your reaction, Mr. Riley, to the argument that the ounce of prevention here, the 35,000 approximately cure, is well worth avoiding the potential sanctions by the IRS, even if we don't fully know exactly what the IRS is saying here in its PLR?
Well, I think including the 35,000 is wrong on its face, regardless of the amount of money. So I would still, I firmly believe the IRS did not did not confirm a net operating loss. So I still believe that there's not a normalization violation. So to be honest, until I actually see the IRS say yes, there is a net interim period net operating loss, I'm going to have to say I reject all ideas of allowing a 35,000 in there just to make the case go away. I think the issue is bigger than that. It's bigger than 35,000. I mean, that's pennies when we're talking about how big this company is. But the issue itself is huge. So I would say no.
How would you proceed that the commission move forward then? If we follow your argument and say no, is the OPC going to ask for a PLR, or are we going to direct Missouri American to ask for another PLR? What would be your thought then?
Well, our central argument is that the Internal Revenue Service did not confirm the net operating loss. So we believe the commission should act the same way that it did in the last two cases and say, we don't believe there's a net operating loss. We don't believe that the IRS said there's a net operating loss. As I said in testimony, I don't believe they got enough information to actually say there's a net operating loss or not. But I would have to, somebody, if not the company, public counsel. I've started to look into how to contact the IRS and, question them. They, of course, aren't very forthcoming with answers unless you're rather official about it. But I believe the commission should give the same report and order that they did in the first two, and let the company contact the IRS and have them certify, if for lack of a better term, certify a net operating loss, or ask them how they're going to correct it on their books.
Okay, thank you. I'm sorry I took up a lot of time with those. Are there any commissioner questions for Mr. Riley? Okay, hearing none, we will go back to re-cross-examination of Mr. Riley. First will be staff, Mr. Johnson.
Thank you, Judge. I think I only have very few questions. Mr. Riley, the judge asked you about inclusion of NOLs in an ISRIS, and I believe you responded that you did not believe an NOL can be determined on an interim basis, that there has to be a tax return. Is that correct?
I believe so, yes, sir.
So assuming in a given tax year, a utility were to show generation of a new NOL amount, would it be your position that that NOL should be reflected in an ISRIS?
No, I do not.
Do you believe an NOL could ever be reflected in an ISRIS?
Yeah, if it ended at, I guess, at the end of a tax year, I guess it could be. But
if the ISRIS period ended at the end of a tax year? Is that what you're saying?
Just speculating there, but in order to have an NOL, you're going to have, according to the IRS publications, you're going to have a tax return. It would be, to be in an interim period, to say you have a net operating loss for an 8-month period, but not have a tax loss at the end of the year. I guess you're kind of contradicting yourself there, because the commission is acknowledged that an NOL is a tax return item, and a tax return is an annual thing. So tax and net operating losses are built in by several different things. There's more than just accelerated depreciation and repairs that are going to cause a net operating. But it's not as simple as having accumulated deferred income tax, which you calculate straight on the asset. So I don't believe you can have a net operating loss in interim period.
And would you agree with me that an ISRIS is calculated based upon the amount of ISRIS costs eligible for recovery during the period in which the surcharge will be in effect and upon the applicable customer billing class?
That's my understanding, yes.
Okay.
Mr. Johnson, could you repeat that question?
Yes. The question was, and would you agree with me that an ISRIS will be collected based upon the amount of ISRIS costs that are eligible for recovery during the period in which the surcharge will be in effect and upon the applicable customer class billing determinants utilized in designing the water corporation's customer rates? And with that, I think that concludes my question. Thank you.
Okay, and recross from Missouri American, Mr. Cooper.
Yes, Your Honor. Mr. Riley, do you still have that schedule from Mr. Wildy's testimony that we talked about earlier? JRW-2?
Yes, sir.
Would you agree with me that the IRS recognized or noted the commission's prior decision as to this issue?
I can't tell you if they recognize it.
Well, why don't you have it in front of you,
Sure,
I take it.
probably take to the paragraph where it is mentioned that all the
hold on
parties
just a
to the
minute.
case.
Bev, you're muted. Yeah, Bev, you're still muted.
Okay, if Mr. Cooper could start again with what he was saying. They were both talking at the same time.
Apologize.
All
right. I think my initial question was whether Mr. Riley believed that the IRS recognized the commission's decision in the private letter.
And I'm not sure if I could use the word recognize. They did, the Missouri American Water included discussion of the case in their presentation. Now, what the IRS does, sure.
So, again, if you have schedule JRW-2 before you, please turn to page 9 of 23.
Okay.
And I don't know, maybe 2/3 of the way down the page, there's a paragraph that starts with differing assertions. Do you see that?
Yes, sir.
And again, this is information from the public version, so not confidential, but would you agree with me that the private letter ruling states at that point that differing assertions were made as part of the surcharge case, period? Ultimately, the commission in its final order determined that because there was not an NOL expected to be generated in year 4, no portion of the NOLC deferred tax asset can be associated with the surcharge property. Is that a correct reading?
Yeah, it is, sir.
Okay. That's all the questions I have, Your Honor.
Thank you. And we have redirect, Mr. Kleiser.
Thank you, Your Honor. Oh, okay, there we go. Mr. Riley, can you hear me now?
Yes, sir.
Okay, there we go. I thought I had a problem. You were just asked a question by the attorney from Missouri American Water regarding what the commission recognizes, and you were discussing, I think, at a certain point, how does the IRS handle the facts presented to it in a private letter ruling request?
Well, it's my understanding, and from what I've read from the IRS website, is that they take the facts presented to them and apply them question and come up with a legal determination.
And in this case, was it an unambiguously presented fact that the company had a net operating loss?
I wouldn't say unambiguous. They pointed out that they had a net operating loss.
So your understanding then is that the IRS took that at face value and made a determination based on that fact?
That is my understanding. That's how I read the answers to the questions in the letter ruling.
All right. You were asked several questions both by the commission and staff regarding, a net operating loss in the period in question here. And I think at one point, the commission asked a question, essentially, what would happen if I changed the standard from they didn't have a net operating loss to there was insufficient evidence of a net operating loss. Do you recall any of that?
Oh, yes, sir.
All right. I don't suppose you have a copy of what was introduced as OPC Exhibit 200, the tax returns for American Water for 2018? If not, I can forward that to you right now.
I can find it.
I'm going to go ahead and forward it to you right now, and hopefully you'll receive it. And then, Judge, while we're waiting on that, I believe that my next round of questioning is going to require us to go in camera because this document is confidential. So I guess I'll get that started now. I apologize.
No, that's all right. Thank you for the heads up. I will get that process started and let you know when we are in camera.
I have the tax return up now.
You have the item?
I have the item in front of me now.
All right. Well, we're going to wait until we go on in camera.
Yep, that'll take just a minute because of the delay in the live stream.
the end of 2019 and 2020 for that matter, if they had a if they didn't have a net operating loss, how would they fix that? How would they correct that? Because the net operating loss would obviously, if you were claiming some sort of interim, it obviously went away by the end of the year. So how would you fix the inclusion of a net operating loss in rate? So I don't know if that answers your question, but I've got that problem that an interim net operating loss, that not have one at the end of the year, is kind of inconsistent.
All right. I think that sufficiently concludes what I needed to go in camera for. Thank you, Judge.
Thank you. If everyone would be patient, it'll take just a second to get us back to live streaming because of the delay. Okay, let's go ahead and come out of being in camera. We are still on the record. And Mr. Kleiser, do you have any further redirect of Mr. Riley?
Unfortunately, I do, Your Honor.
All right, please go ahead.
Mr. Riley, you were asked a question by the commission regarding the ounce of prevention issue, how that affected this case. You had mentioned in response that there were dramatic ramifications that could arise if the commission made a decision regarding the NOL in the way that Mark wanted to. Can you please elaborate on that?
Well, if you're claiming in other staff testimony and the other Israelites all claim the same thing, if you take this argument of an NOL and actually apply that and say, okay, you have an NOL, any company can come in for a rate case and they can claim this massive NOL for all these things that aren't in rates yet. So
sorry, sorry.
Rate makes, okay.
Mr. Riley, Bob's got a question.
Could he start? I'm sorry. Could he start his answer again?
Sure.
And try and get as close to the mic as you can, Mr. Riley. We appreciate it.
What would happen if this argument is believed, and that there's actually an NOL prior to rate making, that you're going to have a utility come in after 3 years and claim we have a net operating loss for all this plant that hasn't been put into rate, and we're going to offset accumulated deferred income tax against this, for what I believe, bogus NOL. So the ratepayer is going to, of course, going to pay for this, because if you're offsetting all that accumulated deferred income tax, you're raising rate base, and this is rate base rate of return, you're going to see rates just skyrocket. I mean, this would be huge. You got a company coming in with $600 million worth of wind. You've got Missouri American going to come in with even more plant that isn't ISRS qualified, and they could claim a net operating loss for a lot of things. You've got, all these companies can come in and say, well, we haven't had a rate case for 3 years. We put all this stuff in the, into service, and we got a net operating loss. That tears at the very core of rate-based rate of return rate making. It would probably require federal, some sort of federal law changes.
Are you familiar with the West? I apologize. I thought you'd finished speaking. Please continue.
I don't think the IRS ever, my argument is the IRS didn't say there actually was an NOL. But if this argument goes past this commission, it's going to be huge for every utility that comes in.
Are you aware of any other utility in the state of that claims a net operating loss in the same manner that Mock does in this case?
I am not aware of anybody.
Are you aware of any utility outside of the state that claims it in the same manner that Mock does in this case?
I have not heard of one.
You were asked questions regarding what determination the IRS made with regard to the private letter ruling. And I believe that you've sort of already touched upon this, but was the IRS ever asked if a net operating loss could occur on an interim basis?
I never read where they were asked to acknowledge the net operating loss.
Well, that was actually going to be my second question, but all right, we'll move on. That's fine. Mr. Riley, is it your belief that it is possible to assign portion of the revenue collected through base rates to an ISRIS case? Or rather, to ISRIS plants? Let me put it that way.
Yes, I do. The
Can you please explain why?
Well, the ISRIS plant has actually replaced plant that is in service. So as soon as that pipe, in this instance, as soon as that pipe and hydrants are in service, they are technically producing revenue because they're.
I need that sentence repeated again.
Okay. The pipe in question is now replacing pipe that is in rate. It is now part of the system, and we're not talking about rate making now. We're talking about actually, functioning within the system. It is a part of the current rates and responsible for revenue.
Sorry, give me one more second, sorry. I need to pull up the stipulation of facts. In that same regard, with as far as revenues go for the ISRIS plant, the term net operating loss, according to the stipulation of facts, is defined as the excess of operating expense over revenues. Is there anything that indicates that the revenues have to be exclusively based off of the rates charged for ISRIS plant in the IRS, to your knowledge? Go ahead.
I would have to say no, because the net operating loss is outside of the ISRIS case. When you consider the timing of an ISRIS case, which is revenue requirement, and this net operating loss is revenue recognition, it's outside of the case. So you kind of lost track of your question now, but Could you repeat the question so I can get to an end?
Well, with regard to the revenue that's assignable to ISRIS plan, is there anything in the definition of net operating loss that indicates that revenue has to come from rates charged for that plan?
The short answer would be no. It would. You would be charging revenues prior to the ISRIS rate making.
And the net operating loss is not asset specific, correct?
That is my contention, yes.
All right, let's move on. All right, very near the beginning, Missouri American Water asked you some questions regarding, I'm going to pronounce it SEAC. I know others have chosen a different way. And the schedules that you included in your amendments. Oh, do you recall this? Let me start there.
Yeah.
Specifically, there was a discussion of the 4 attachments or 3, however many attachments you want to talk about, and line 30, where the company was identifying SEAC. Do you recall that?
Yes, sir.
Okay. So here's the question. Did the fact that the company identified SEAC in line 30 of those mean that SEAC was included in calculation for net operating loss that's being used to calculate the adjustment for this case?
No. SEAC in this case is, as counsel there pointed me to, is a whole. We're actually talking apples and oranges. The SEAC in the case is something that gets deducted from rate base. It gets included in tax timing differences. However, the NOL is not a ISRIS component. It wants to be. They say no revenues prior to the ISRIS rate making revenues. So if you're going to go apples and apples, you have to talk about SEAC outside of those schedules. But you have to talk about SEAC as a taxable income, because that's the way it is now in the income tax rule. Just like a net operating loss is the income tax component, that what you talk about SEAC in the rate case is completely different than claiming SEAC as a taxable revenue and offsetting your accelerated depreciation prior to the ISRIS rate making.
Can you describe, hopefully in brief, how exactly the $35,000 approximate adjustment calculated?
Well, it's my understanding, and I don't have the tab handy, but they calculated the revenue requirement that should have been included in feel free to correct me there. It should have been included in the last 3 ISRIS cases, and then figured out the amount that should have been in there, and then applied interest to it, and that is how they came up with the amount for each case, and that totaled $35,300 some odd dollars.
And to be clear, when the company calculated the revenue requirement that it needed for each of those 3 cases, they did not include the SEAC as part of that offset to NOL, as you say needs to be done?
No, they did not.
All right, thank you. I have no further redirect.
Thank you, Mr. Kleiser. The next witness that I have on our list is Mark Oligschlager. Mr. Oligschlager, if you would please unmute, I will swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, and go ahead, Mr. Johnson.
Judge, as a preliminary matter, I believe we will mark the direct testimony of Mr. Oligschlager as exhibit number 300 and the rebuttal testimony of Mr. Oligschlager as exhibit 301, public and confidential.
All right, so marked.
Will you please state your name and spell your last name for the record?
Yes, my name is Mark L. Oligschlager. My last name is spelled Oligschlager.
By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission. I am the Director of the Financial and Business Analysis Division.
And are you the same Mark Oligschlager who prepared or caused to be prepared direct testimony in this matter marked as Staff Exhibit 300 and rebuttal testimony in this matter marked as Staff Exhibit 301 public and confidential?
I am.
Do you have any changes or corrections to your testimony?
I do not.
Is your testimony true and correct to the best of your knowledge and belief?
It is.
If I were to ask you those same questions today, would your answers be substantially the same?
They would.
Judge, at this time, I would offer exhibits 300 and 301, public and confidential, into evidence.
All right, we will start with Missouri American. Mr. Cooper, do you have any objections to the admittance of those exhibits?
I do not.
Thank you. And Mr. Kleiser, do you have any objections to the admittance of those exhibits? Oh, Mr. Kleiser, sorry about that. I muted you on my end. Mr. Kleiser, do you have any objections?
I had muted my phone in addition to muting the call, and therefore I apologize. I do not. I'd answered twice.
Thank you. Without objection, the exhibits are so admitted. Please go ahead.
I tender the witness for cross-examination.
Thank you. And Mr. Cooper?
No questions, Your Honor.
Thank you. And Mr. Kleiser?
Good afternoon, Mr. Oligschlager.
Good afternoon.
The good news is that, fortunately, most of the cross I had prepared has been rendered irrelevant. So this should hopefully be relatively short. That being said, I am going to email an exhibit to counsel right now, who I will then hope to forward on to you. So I ask that you bear with me for 1 second. I apologize. All right, I have now forwarded an exhibit to counsel, who will forward it on to you shortly. Judge, while that process is going on, it's not my intention to have this exhibit marked or offered. I just want to review it with the witness. So laying that out there for what it is.
Thank you, Mr. Kleiser. I appreciate the update.
And Mr. Oligschlager, can you please tell me once you've received a copy from your counsel?
I will.
Mr. Kleiser, if you have any other exhibits that have not previously been distributed, could you go ahead and do that now? Thank you.
I hope this is actually my last one.
Thank you.
Right, I have forwarded on the exhibit to Mr. Oligschlager.
And I have forwarded it on my end.
I have the exhibit and I have opened it up.
All right. For the sake of the record, I'd like this to reflect that this is what the OPC is purporting to be a copy of Karen Lyons' rebuttal testimony filed in docket number WO-2020-0190. Again, I won't be asking Mr. Oligschlager to verify that, nor will I be offering it. I'm instead simply wishing to know whether or not he agrees with certain statements that Ms. Lyons said from his own personal opinion. But again, I'd like the record to reflect what I'm referring to. So Mr. Oligschlager, if you could turn to page 3 of that document.
I am there.
If you could read aloud for me just lines 3 through 6.
All right. Question, is it possible to determine what specific rate-making elements give rise to an NOL? Answer, no. NOLs are calculated on an overall basis and are not split out for accounting purposes by the various tax deductions that may contribute to an NOL situation.
Now, Mr. Oligschlager, I simply ask, do you agree with the statement that Ms. Lyons provided in response to that question?
I do.
Thank you. And then can we do the same thing for lines 16 of page, hang on 1 second. Make sure I get this right. Actually, you know what? I won't ask any further questions. And I have no further cross. Thank you.
Thank you, Mr. Kleiser. The bench does have a couple of questions. Mr. Oligschlager, I'd like to follow up on your answer, that very last answer to Mr. Kleiser's question. What is the difference between your view then and public counsel's view, given that you agree with that statement that NOLs are calculated on an overall basis and not split out for accounting purposes?
Well, I think where that inquiry was going is involves the question of assuming you have an NOL situation for a company or a utility, how do you split that out between different rate elements? And I think what staff has indicated in the past, and we would still agree with, is you really can't, not by any, there's no one correct way to do that if you have to do it. And to us, to staff in past cases, the whole question was moot because we believe there was no NOL generated during the ISRIS period, so the question really didn't need to be dealt with. But Missouri American thought elsewise and argued with or asked the IRS to rule that the so-called with and without method should be used to determine the amount of NOL that should be assumed, hypothetically, be imputed into the ISRIS rate process. So it's a convoluted way of probably answering your question. I don't know that we disagree with OPC on the basic technical point. It's just that the IRS ultimately determined to agree with the company and disregard the staff's and OPC's arguments in the case.
Thank you. I'd like to talk about my ounce of prevention quote that I asked Mr. Riley about. I felt that your testimony also leaned in that direction. Can you expand on that? Because I'm worried now that from what Mr. Riley said, is that this one small change could mushroom into a much larger issue for the commission down the road.
Let me answer that in a couple of pieces. First of all, is this going to be a precedent for other utilities? It is stated within the PLR, it is stated within all PLRs that they are not to be taken as precedent for anyone else other than the taxpayer in the specific circumstances that they discuss in their PLR request. Staff interprets that as meaning that the PLR, to the extent the commission needs to take that into account, only applies to Missouri American, only applies to Missouri American as long as it has an NOL on its books, and only applies to ISRIS rate proceedings, not to general rate cases. So for that reason, no other utilities, or at least staff use it as this really doesn't establish precedent for any other utility or for any other venue other than ISRIS cases. So I think the impact is quite limited. And just because another company in another type of case may raise the same arguments, I don't think they can use the PLR as direct support for that. And we would look at it in the same way as we did in the past for Missouri American. Maybe to talk about the ounce of prevention concept a little bit, I agree that in this particular case, in these particular circumstances, the commission should take an attitude of an ounce of prevention, preventing something worse happening overall. And by something worse, I mean, the potential loss of the accelerated depreciation deduction. The reality is that what the IRS said in this PLR only applies or only must be taken into account for much less than 1% of the dollar values that were actually at issue in the case. I think in each case, there was somewhere between 800, 900,000, maybe up to $1 million at issue. When all is said and done, because of how the IRS ruled on the PLR, only somewhere between $5,000 to $10,000 per case ultimately was at issue and needs to be charged to the customers. So given the hypothetical choice of do we fight what the IRS is doing somehow or do we accept it, given the very small volume of dollars, I don't think that would be a hill I would recommend the commission to die.
Thank you. And to follow up on that concern, can you give me some examples of tools that the commission has available should the IRS reverse itself? Should OPC call the IRS and say, hey, you just assumed this fact, and the IRS says, oh my gosh, you're right. Do we have prudence reviews, true ups? How would that work if we needed to walk this back? if the ounce of prevention was unnecessary?
Well, and I don't have any kind of detailed knowledge of what recourse the commission might have if it ultimately chooses not to accept the IRS's findings in this particular case. I assume there may be some way to appeal in court. I assume there may be some ways to appeal directly to the IRS. It could be that the company would be able to submit a new PLR request based on whatever information was included in the commission's order. But beyond that, I don't think I could be any more specific than that.
My question was a little bit different. Let's assume that the commission says we're going with this ounce of prevention strategy, and by the time of the next general rate case, would the commission then have an opportunity to look back on this 35,000 and say that actually wasn't the correct finding? The IRS has issued a new statement, or whatever hypothetically you'd want to fit in. Is there a way to walk back this 35,000 adjustment at the next general rate case or sometime in the future?
Well, I think the commission retains its prerogatives to set rates, including ISRS rates. And as I noted in my testimony, certainly the IRS does not directly set ISRS rates or any other kind of utility rates in its pronouncements and its PLRs. So I think technically, yes, the commission would have the ability to change its mind. Parties would have the ability to ask it to change its mind. And based on the evidence, they could reverse themselves. At this juncture, I don't think that would be a wise course of action, particularly if the dollars involved remain as small as what they have been now and in the past cases.
Okay, and one last question. In reference to your rebuttal testimony, beginning on page 8, could you explain your concern with Mr. Wildy's direct testimony from his pages 11 through 12 without getting into confidential information?
Well, I can certainly try. I interpreted Mr. Wildy's rebuttal testimony, as well as other comments he has made, off the record, both going back to past cases as well as this case, as Missouri American believes there may be a problem in the normalization sense for the commission to deduct deferred taxes in ISRS cases from rate base when the underlying revenues from the ISRS have not yet been charged to customers. My concern is that's what we do as an absolute standard course of action, not only in ISRS cases for close to 20 years now, but in general rate cases. What the commission does is they establish a rate-based cutoff point. They reflect plant balances out to that point, same time. They match that with the same values at the same time for accumulated depreciation, and they do the exact same thing for accumulated deferred income taxes. And they derive those values from the company's books. The company does not wait to receive revenues before they book the associated deferred taxes, accumulated depreciation, for that matter, plant dollars. And to now suggest that what the commission has been doing, specifically in ISRS cases for close to 20 years, somehow now falls afoul of the normalization provisions, which have also been in place for decades, to me, that's simply not credible.
Thank you. Are there any other questions from commissioners? Any commissioner questions? Hearing none, let's move to recross examination. Mr. Cooper, you're first up.
Thank you, Your Honor. Mr. Oligschlager, just very briefly, in your last answer, I think you were describing your disagreement with Mr. Wildy's testimony as to ruling 8. Is that correct?
Yes.
I believe you were at the hearing earlier today, and would you agree with Mr. Wildy in that the adjustment that's been proposed here is appropriate under ruling 9?
Well, I didn't necessarily fully follow that. My understanding is the request for ruling 8 is fundamentally different than the request for ruling 9 and 10, because ruling 9 and 10 assumes the existence of an NOL, whether actual or hypothetical. As I understand it from Mr. Wildy's testimony, ruling number 8 is not dependent on an NOL at all. And it might apply in situations where a utility is not in effect in an NOL situation. So I'm not sure how to reconcile what Mr. Wildy said earlier than how I interpret at least his testimony. Perhaps that bears further discussion, and to the extent I'm not understanding ruling 8 fully, I would be happy to be further educated.
Well, let me back up, because really my question is more sort of high level than where you were headed with that, which is you've recommended that the $35,328 adjustment be made in this case, correct?
Yes.
And you're satisfied that ruling 9 supports that adjustment, correct?
That position is based upon our interpretation of ruling 9, yes.
And if the adjustment is made in this case, and it's made based upon your understanding of ruling 9, ruling 8 sort of falls away. There's no need to address that here in this case, is there?
I think I would agree with that analysis.
That's all the questions I have here.
Thank you, Mr. Cooper. Mr. Kleiser.
Good afternoon again. In response to the Commission's question regarding the ounce of prevention, you basically stated something to the effect that this only applies to Missouri American Water, it only applies if it had an NOL on its books, and it only applies to ISRIS rates or cases. Is that fundamentally correct?
Yes.
I want to focus on just the second one. So again, your position is this only applies, the private letter ruling only applies if the company actually has a net operating loss on its books.
Well, I think, as has been discussed at great length, both in testimony here today, the IRS appears to have a different working definition of NOL in the context of ISRIS rate cases than staff or OPC in the past. But with that caveat, I think I agree with your statement.
Your determination that the IRS has a different working understanding, that's based on the language in the fact section where the IRS where the IRS included as a fact that there was an NOL or a taxable loss as they referred to it. Is that correct?
Hold on, Mr.
Kleiser. Could you repeat that question again?
I will do my best. That was a little convoluted. All right. Your determination that the IRS has a different understanding of the NOL as it relates to ISRIS cases was based on the fact that was included in the private letter ruling that said Mock had an NOL. Is that basically correct?
Oh, yeah, I think I stepped through how we analyzed it in my direct testimony and rebuttal testimony. And basically, we relied upon certain statements made by the IRS in what I think was labeled the facts section, and how those interrelated ultimately with how the IRS ruled on ruling request number 9.
Ruled on what?
Would you happen to have a
Ruled on ruling request number 9.
Thank you.
Would you happen to have a copy of the private letter ruling in front of you?
I can get it. All right, I have it.
Can you go right to the bottom? Right above the, sorry, I'm on page 22 of 23 from the
Okay.
version that was attached to Mr. Wildy's testimony. The first paragraph starts with 12, the next with accept, the next with this, and the next one with this ruling is based upon information.
Yes, I'm
Do you
there.
follow?
Yes.
You would agree with me that that penultimate paragraph reads, this ruling is based upon information and representation submitted by taxpayer and accompanied by penalty of perjury statements executed by an appropriate party. While this office has not verified any of the material submitted in support of the request for rulings, it is subject to verification upon examination. Agree with that?
I do agree with you that that is what this states.
If the IRS were to later make a determination that there was a misstatement of fact about the existence of an NOL and withdrew its PLR, would that change staff's position?
Our entire position on this issue in this case is based upon the PLR. If the company were under some circumstances to withdraw that or revoke it, yes, that would change our position.
I don't think I have any further. Well, nope, I have one last question. And this one's almost out of curiosity. Is it your position that a company can both have a net operating loss and not have a net operating loss simultaneously?
I think the best way to answer that is no. I think what obviously gives rise to the question is, again, the IRS and Missouri American providing a different understanding and definition of NOL than what staff understood and understands that definition to be. So I suppose an NOL may be considered not to exist, say, in staff or OPC's understanding, but it might exist in alternatively Missouri Americans or the IRS's.
And again, the IRS understanding in this case is what was printed in the facts section of this private letter ruling. That's where staff is coming from.
Yes.
Oh, now I have no further questions. Thank you.
Thank you, and back to Mr. Johnson for redirect.
Thank you, Judge. Mr. Oligschlager, back at the beginning of your questioning, Mr. Kleiser for OPC had you reference the testimony of Karen Lyons from a prior ISRIS proceeding. Do you remember that?
I do.
And essentially, that testimony stated that NOLs are calculated on an overall basis, and you agreed with that statement, correct?
Yes.
Is that fact the basis of staff's recommendation in this case?
No, I mean, and maybe to give that a little more explanation. No, in prior ISRIS cases, company argued, hey, an NOL exists, and this is how you should account for it in the context of the ISRIS rate case. We disagreed in prior cases with these proposed with or without method. Believed it was not an appropriate way of assigning an NOL to ISRIS cases in the event that such an assignment was necessary, and suggested alternative ways of doing it. So, I mean, regardless of whether NOLs are calculated on an overall basis or not, there may be some circumstances in which there's a legitimate NOL existing, which would need to be allocated in some way to ISRIS plant as opposed to non-ISRIS eligible plant or other tax deductions that may give rise to the NOL. So.
Right. Also, the judge directed a couple questions to you regarding the ounce of prevention And in your response, you mentioned your belief that the PLR would only apply to Missouri American and only if they had an NOL on their books. Do you remember that?
Yes, and in addition, in the context of Israel's cases, yes.
When you use the term NOL on their books, are you referencing the generation of a new NOL amount in a given tax year or something else?
Well, that's how we would interpret the criteria for including an NOL in Israel's case, or in any rate case, that some NOL be currently generated within the period in question. Again, the IRS, I think, has effectively taken a broader view that anytime a company has a pre-existing NOL on its books, even if it's being used and no additional amounts are being generated, would trigger ruling number 9. So.
And finally, Mr. Kleiser asked you about the facts contained in the PLR. Did staff provide comments which were attached to the company's PLR request?
We did, and the approach we took was the company made 12 different requests for rulings. I think some of them weren't necessarily directly germane or related to the issues in prior interest rate cases. 5 of them appeared to be, we provided comments on those 5, including certainly the basis for the staff's and ultimately the commission's positions and decisions in those cases. And I believe it was clearly expressed that the staff, staff took the position and the commission has adopted it, that since no NOL was generated during the applicable ISRIS proceedings, none should be recognized for ISRIS rate purposes. So what the IRS did with those representations, whether they took them into account, gave them any consideration, the document is silent. So.
Do you have any reason to believe the IRS did not take those into consideration?
My concern would be, well, first of all, they don't even mention the staff's comments in the PLR, so certainly they don't indicate they took it into consideration. And plus the PLR, maybe this is standard for all PLRs, is almost totally silent as to why the IRS has drawn the conclusions that it did. I think OPC is correct in the limited sense that they appeared to take certain factual assertions made by Missouri American and accept them, as opposed to other assertions that might have been found in the staff comments. But again, they didn't talk about that, so I don't know what they took into account and what they did.
All right, thank you. I have no further questions.
Thank you, Mr. Johnson. That will take us to the first of our last 2 witnesses, Ali Arabian. Mr. Arabian, if you would unmute your phone or computer, I'll swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes, I do.
Thank you. And direct examination, Ms. Johnson.
Thank you. I believe we will mark Mr. Arabian's direct testimony as Staff Exhibit 302 and the supplement to direct testimony of Mr. Arabian as Exhibit 303.
You so marked.
Mr. Arabian, will you please state your name and spell your last name for the record?
My name is Ali Arabian, spelled Arabian.
By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as a utility regulatory auditor too.
And are you the same Ali Arabian who prepared or caused to be prepared direct testimony in this matter marked as Staff Exhibit 302 and supplement to direct testimony marked as Staff Exhibit 303?
Yes.
Do you have any changes or corrections to your testimony?
No, I don't.
Is your testimony true and correct to the best of your knowledge and belief?
Yes.
If I were to ask you those same questions today, would your answers be substantially the same?
Yes.
Judge, at this time, I would offer Staff Exhibits 302 and 303 as evidence.
Thank you. Are there any objections to the admittance of those two exhibits? Mr. Cooper?
No, Your Honor.
Any objections, Mr. Kleiser?
No, Your Honor. Thank you.
Thank you. They are so admitted. Mr. Johnson?
Thank you, Judge. At this time, I would tender Mr. Arabian for cross-examination.
Thank you. And Mr. Cooper?
No questions.
Thank you. And Mr. Kleiser?
No questions. Thank you.
Thank you. And are there any commissioner questions? Okay, that brings us to our last witness for this evidentiary hearing. Witness Matthew Barnes, if you would please unmute your phone, and I will swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And Mr. Johnson?
Thank you. Staff will mark Mr. Barnes' direct testimony as Staff Exhibit 304.
Go ahead.
Will you please state your name and spell your last name for the record?
My name's Matthew J. Barnes, B-A-R-N-E-S.
By whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission in the Water and Sewer Department as a Utility Regulatory Auditor 4.
And are you the same Matthew Barnes who prepared or caused to be prepared direct testimony in this matter marked as Staff Exhibit 304?
Yes, I am.
Do you have any corrections or changes to your testimony?
I do, just a couple. On page 3, line 6, the word table 1 in that second sentence should be stricken out, and the sentence should read, "Please see the table below for a side-by-side comparison." And the next sentence that starts with table 1 needs to be stricken and replaced with the word this, T-H-I-S. And that's all I have.
With those changes, is your testimony true and correct to the best of your knowledge and belief?
It is.
And if I were to ask you those same questions today, would your answers be substantially the same?
Yes, they would.
Judge, at this time, I would offer Staff Exhibit 304 as evidence.
Thank you. Are there any objections to Exhibit 304 being offered onto the hearing record? Mr. Cooper?
No objection.
And Mr. Kleiser?
No objection.
Thank you. Without objection, Exhibit 304 is admitted onto the hearing record. Mr. Johnson?
I tender the witness for cross-examination.
Thank you. And Mr. Cooper?
No questions.
Thank you. And Mr. Kleiser?
No questions. Thank you, Your Honor.
Thank you. And are there any commissioner questions? Okay, hearing none. We are in the last couple minutes of the hearing, so let's go over some last minute announcements. Just I want to remind everyone, exhibits must be submitted to the email address exhibits psc.mo.gov. Let's set a deadline of Friday for that submission.
Your Honor?
Yes.
When we email those in, would you prefer that they be titled as Exhibit 200, 201, et cetera, or do you want them to be titled what they should be in terms of, I just need a little bit of clarification how to send the files in, if that makes sense, or is it, how would you like them titled, basically?
As it's been explained to me, the data center will make sure that all exhibits are correctly marked. So if you have the ability, wherewithal, and the time to mark your exhibits with the exhibit number, that would be great. And if you don't, my understanding is that the data center will take care of that for the parties. Does that answer your question, Mr. Kleiser?
Yes, it does. Sorry to bother you.
No, you're fine.
Hey, Judge, it's Commissioner Roop real quick.
Yes.
Hey, my battery's at 3%. I know you're in your announcements. I just wanted to say great job today. Thank you for everybody for the difficult situation. Even with the technical difficulties, just great job for handling it and getting this done.
Thank you, Commissioner. I appreciate the kind words. Last couple announcements. Bev, we have requested an expedited turnaround so that we can get a transcript by tomorrow evening. Yes. We have briefs due in this case Friday.
Let me just hold on a second.
Okay.
Is there any way it could be Friday morning?
Let me ask the parties. We have.
Would it be possible?
Go ahead,
Sorry.
Mr. Kleiser.
I know that traditionally briefing has been due on a weekday basis. Would it be possible to move briefing to be due on a weekend?
I'm hesitant to do that. I was volunteering myself to work on the weekend. The commission will likely have 2 agenda meetings related to this case. The first as a discussion coming up next Wednesday, and the second with the commission deciding its order in this case. Let me look at the, that would be June 17th. And that is to meet the, remind me when the operation of law date is. I think it was the 30th. So that's why we have the compressed schedule on the briefings. I'm fine with extending that, but my deadline is noon on Monday. I'm willing to try and extend that out. Bev has asked for Friday morning. I'll go down the council list, and Mr. Kleiser has asked for sometime Saturday or Sunday. I'll cover that in a second. Mr. Cooper, what are your thoughts?
Well, I don't have my calendar in front of me. Judge, do you have in front of you when the reply, because we were going to do reply briefs as well, weren't we?
I only had scheduled one round of briefs.
Okay. Then I guess I'm to a certain extent in the same boat as Mr. Kleiser. I could use another day or so probably.
I'm fine with going until Sunday. Monday morning, like 8 sharp?
Either works for me. Either works for me. I can make it work too. So.
Okay, let's call it.
Yeah, I'd add only that any amount of additional time would be helpful.
Okay, Mr. Johnson, thoughts?
While I would very much prefer not to work on the weekend, I understand the short time frame with this case may require it. I believe I can accommodate any schedule the parties prefer.
Okay. Let's amend the schedule here and now. I will not be able to get that out as a written order until, what is today? Wednesday until Thursday. I have to run and go pick up the kids after this. Final briefs are due Sunday. Bev, transcript is due Friday, as soon as you can. And there will be no reply briefs. Are there any other issues before we adjourn? Okay. We are adjourned and off the record. Thank you all for participating and thank you all for being patient.
Thank you, Judge.
Thank you.
Thanks.